you.
Yes. Yeah. This hearing is in the matter of case number CFI 41 and is being held by way of video conference before Justice Wayne Martin, who is appearing with us from Australia. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Simmons & Simmons Middle East LLP. Lead counsel is Ms. Annalise Day KC, assisted by Mr. Daniel Edmonds. The defendants are being represented by El Tamimi and Company. Lead counsel is Mr. Tom Montague Smith KC, assisted by Mr. Matthew Watson. Will the judge and the parties representatives please confirm that the situation is as I have stated?
Yes, I confirm.
I confirm too.
Good, thank you. Ms. Day. Thanks, Aladid. Ms. Day.
Thank you. I hope you have received the updated bundle. There was Justice Jeremy Cook's judgment added, a couple of authorities which you may go to, and then the statement of costs.
Well, I've got the bundle as it was when I logged on about 20 minutes ago. So is
great? That should be up to date. Absolutely.
Okay. Good. And if it helps, I've read what I consider to be all the material documents, including my own earlier decision, which was like a trip down memory lane, but at least it reminded me of what the case is about. But anyway.
Absolutely. Yes. I think we're both very conscious that you've dealt with a lot of these cases between you and Mr. Justice Cook. You seem to have dealt with most of them. And sometimes the summaries are perhaps not as full. So you may have your own views of the facts of that case. Of course, as you yourself have said, it all depends on the facts ultimately. But what I propose to do is there are two broad areas for us to look at today. First of all, if there's no conflict of jurisdiction, is it in the interest of justice to lift the stay? And then obviously the question of conflict also has to be decided. I was proposing to deal with them the other way around, so to deal with the interest of justice first, because you will be aware that the respondents are saying that you have no jurisdiction at all, effectively, to interfere with this because it's a consent order. And so I hope.
Well, Mr. Montague Smith's shaking his head. I don't know if it's jurisdictional. You're saying that I shouldn't. Is that it,
yeah,
Mr. Montague Smith?
No,
okay.
Yes.
I accept you have the power.
Yes. Okay. All right. Thank you.
Well, in a sense, that's a useful place to start, because I think that we are in disagreement as to the test that you should apply in order to determine whether or not the court should lift the interim stay. What we do make clear is that even if you were against us and were to find that the exacting test urged on you by the respondents was to apply, then in fact we would meet it in the circumstances of this case. The test that the respondents say applies varies. It's described as exceptional circumstances in 7.1 of the skeleton, a material change of circumstances in 7.2, even higher than exceptionally, that's paragraphs 45 and 46 of their skeleton, and then very exceptionally at 47. But we say the correct test is actually that set out in the Credit Suisse case, which is one of your cases, and that is to be found in tab F/9. And I wanted to take you to paragraph 39 of that, which should be at 0809 of the bundle.
Yes.
And there you set out very clearly that an interim stay is of its nature temporary, and irrespective of RDC 4.7, necessarily includes the power to lift the stay. The power to lift a stay will be exercised in the interest of justice without constraints imposed by presumptions or onerous conditions, which must be satisfied before the power can be exercised. The stay is an example of a continuing order where the exigencies of case management may be required to be reviewed as the case unfolds. The review of a stay will not, therefore, necessarily be conditioned upon the occurrence of a material change in circumstances. So in other words, where we say you are is that the fact the parties originally agreed to the stay is something that should be taken into account by the court in deciding whether or not to exercise its power to lift the stay. But it's not correct to say that the fact the order has been made by consent means that we have to show that something exceptional has happened or that there's been a material change of circumstances. And what you see in the authorities on this is that the courts have drawn a difference between what are called true consent orders and procedural accommodations, and the latter have less weight. So we see in particular in the English authorities that the judiciary have distinguished between what are called real settlement contracts, so those that compromise a substantive issue between the parties, and then secondly, procedural accommodations, particularly of a case management sort, even if those are made by consent. And what we see is that there's a spectrum with those two things sitting at either end, and procedural accommodations carry much less weight than a true consent order recording a substantive compromise. Procedural accommodations are something to be taken into account, but are of very limited weight, and they do not fetter the court's powers to manage the case in front of the court. And we've added into the bundle the extract from Zuckerman on civil procedure, which has a useful summary of the position in England, obviously, but we say that that should also apply in the DIFC. That's to be found at H/3, starting at page 1200. And you will see there that there's reference to not all consent orders being in the nature of a contract between the parties, and some are merely based on the parties' willingness to submit to an order on certain terms. Even if a consent order does represent an agreement, it may not be an agreement as to substance or settlement, but as to some procedural matter. In either case, the court retains its normal jurisdiction to alter or to vary the terms of the consent order. And then it explains why that is. And then it goes on further down to say, while these distinctions may be clear in theory, they are far from clear in practice, nor are their consequences as certain as would appear at first sight. It is not always easy to identify whether consent order is a true consent order or a lesser consent order. And then there's a reference to the case of Safin, which we'll come on to, where the Court of Appeal confirmed that under the CPR, the court has an unfettered power to vary time limits in all consent orders. So next, I would take you to the case of Pannoni, which you'll find at G7, which is now regarded as the leading case on this issue. It starts at 1018. And what happened in that case was there was an order made by consent that the claimant should file and serve statements of case by a certain deadline. And if they didn't, then they would be struck out. And we say it's worth looking at this case in some detail because the respondent quotes from it, we say, in a way that doesn't give fair representation to what it involved. If we can look, first of all, at paragraph 27, three lines from the, paragraph 27, 1026, page 1026.
Oh, okay. So which case are we looking at? Sorry,
Sorry, G/7, page 1026, and it's paragraph 27. Yeah.
Thank you.
And this is Lord Justice Tomlinson. And if you see paragraph 27 at the bottom, you will see that he says there, it's 3 lines from the bottom, he makes the point I've already made that there's a world of difference between a case management decision made at the instance of one party to which the other party makes no objection, then he refers to CAB Gorman, and a genuine settlement of a substantive dispute as to the party's rights, referring to Weston. assuming there is power to do so where the settlements embodied in an order of the court, it can rarely be appropriate for the court to intervene further than to the extent to which the contract can, by its own terms, pursuant to general contractual principles, be modified or discharged in light of changed circumstances. And then if we can go forward, please, to paragraph 33, which should be on page 1030.
Yes.
Again, he makes the point, in my view, the weight to be given to the consideration that an order is agreed will vary according to the nature of the order and thus the agreement. So again, reiterating, where you have a substantive dispute that's been settled, that factor will have very great and perhaps ordinarily decisive weight. And then he says this, where, however, the agreement is no more than a procedural accommodation in relation to case management, the weight to be accorded to the fact of the parties' agreement as to the consequences of non-compliance, while still real and substantial, will nonetheless ordinarily be correspondingly less and rarely decisive. And then he goes on to say everything will depend on the circumstances that you have to take into account. Also important to note that the court still has a power to vary even what are called true consent orders. And that, if we turn back in this same decision, if you go back to 28, paragraph 28, which is on page 1028.
Yes.
It's about halfway down the page, just above letter C. It says it will no doubt be rare for the court to decline to give effect to the agreement, but the court reserves to itself the power to do so, consistent with the court's general powers of management. And then it talks about why the court needs to ensure that that can happen. And then going forward to 32, paragraph 32, 1030. This is an important paragraph. 4 lines down in paragraph 32, he says the presence of unusual circumstances is plainly not a prerequisite of the jurisdiction to extend time or to grant relief. And then he refers to the ROPAC case, which you will see that the respondents have quoted in their skeleton argument, and he tactfully says that he doesn't agree with what Neuberger said in that, or certainly says he wasn't intending to formulate a rule in that case. And that he says, I think he meant no more than to emphasize that appropriate weight should be given to the parties' agreement. So the quotation at paragraph 42 of the respondent's skeleton is no longer good law in England. It's been superseded by this paragraph, by this decision of the Court of Appeal, who've made clear that you don't have to show unusual circumstances. And then again, that's been confirmed in a subsequent case, the case of Safin. That should now be in your bundle at H/2. And then if we could look, please, at page 1192, it's paragraph 61 of that decision. If we start from the second sentence, he's considering Pannoni, and he's saying that in that case, both Lord Justice Thompson and Lord Justice Lloyd were saying that there was jurisdiction under the CPR to extend any time limits in a consent order, including an order which resolved the substantive dispute between the parties, and even where the parties had stated expressly that time is of the essence. Second point, that discretion is not limited to the existence of unusual circumstances. So reiterating, contrary to what the respondents submit to you, that you don't need unusual circumstances. What you do is that the weight is to be given to the fact of the agreement depends on all the circumstances. The fact of agreement is one, but you always look at all the other factors as well. Just a brief word about the case of Weston and Damon, which you may have seen referred to in these cases, and the respondents also refer to it at paragraph 43 of their skeleton argument. We say that that just doesn't really assist here. That was plainly a case of a true consent order. If we look at the very first paragraph of that decision, it's G/6, and it's page 1007. First paragraph of Lady Justice Arden's judgment, you will see that that was a consent order discharging the defendant receiver from all substantive liability for any failure properly to manage the estate during the receivership. So that is obviously a substantive compromise of the claims, and the stay in this case is simply not in that category.
Yes. A
couple of other general points just to deal with very briefly in the respondent's skeleton before I look at the facts of what has happened here. The respondents say in paragraph 46 of their skeleton that whatever approach is taken in England should apply here in the DIFC with even more force, because DIFC law generally takes a stricter view towards upholding contracts. Now, we say that doesn't assist the court in any way as to how it should deal with case management decisions. And we say the court shouldn't accede to the suggestion that these claims should be stayed indefinitely, because, for example, there's no doctrine of penalties in the DIFC. There's also a submission made to you that the primary role, and I'm quoting here, of an international dispute resolution centre is to hold parties to their bargains. That's paragraph 53. We say that goes nowhere. Indeed, we would say it's the role of an international dispute resolution centre to resolve disputes, and that is in effect what the order that we are seeking. So I'll turn then just to look in a bit more detail about what has happened here. What was the nature of the stay that was agreed to and then approved? What's happened since, and what will happen next? And just to reiterate, even if I'm wrong on the law and you reach the view that we have to show something exceptional to lift the stay, we say that something exceptional has happened here. So on the spectrum of true consent orders leading down to procedural accommodations, we say we're at the end of the procedural accommodations spectrum. And we say that for 5 reasons. First of all, we say that there's been no compromise of a substantive issue. And you are told in the respondent's skeleton at paragraph 3 that the parties by this consent order compromised, quotes, the issue as to whether the DIFC court was obliged to stay proceedings under Decree 19. Now, there's absolutely nothing on the face of the order that suggests, still less represents my client's binding agreement that there was a conflict of jurisdiction. And as the respondents are well aware, in the correspondence that preceded that consent order being signed, it was expressly said that it was not accepted that there was a conflict. That's in a letter of the 20th of December 2021. It's D/4 and it's page 222.
Yep.
So just turn briefly to that. So this is a letter from Simmons and Simmons to Altamini on the 20th of December, and in paragraph 2, you will see there set out. Our client does not accept that there is a conflict, a position which forms the primary argument in our client's response to the JJC reference. It therefore follows that our client does not consider that the conditions for the requested stay are met. And then you will go on to say, but without prejudice to that, we're going to consider whether we're willing to consent on a pragmatic basis to this stay. So it's made very, very clear that there is no acceptance, there is no compromise of the question of whether the DIFC court was obliged to stay the proceedings. Rather, there was a pragmatic accommodation which was made to streamline the proceedings. There wasn't a permanent or substantive compromise of that issue. Indeed, the JJC could have determined that the application was prematurely made because no conflict of jurisdiction arose. And indeed, that's reflected in the respondents' own submissions before the JJC. So all that this stay did, therefore, was procedurally to put the question of conflict before the JJC rather than the DIFC court. And as I say, there's absolutely no compromise of that issue. Second point, the agreement was always conditional on the JJC functioning. And you will have seen the sworn evidence that's been given to you, that the agreement was given on the basis that the JJC would determine the petition within a reasonable time, or at least that the JJC would continue to function. And that's a matter of common sense. There would have been absolutely no merit in having this stay if the JJC was to effectively cease functioning, as has in fact occurred. Now, dealing with some of the points that the respondents make in reply to that, first of all, they try to make much of the fact that we didn't expressly stipulate or expressly say that the DIFC was imposed, depended on the JJC continuing to function. But we say that point helps us. The effect of what Ms. Kitt says at paragraphs 28 to 30 of her statement is that it was so obvious as to go without saying. So this was something that would obviously be assumed, because what would be the point of having a stay for the JJC to determine this if the JJC were not going to determine it? Both parties must have thought, assuming both parties are acting in good faith, that there would be a determination. Obviously, no doubt with hindsight, then one might say, well, why wasn't there a long stop date? But obviously at that point, it was believed that the JJC would determine it. And you also have, and we'll come on to this, some very explicit evidence that reassurance was given that it would be determined. Secondly, the respondents say that some of the concerns about the JJC predated the DIFC stay being agreed. The short answer to that is, while some did, many did not. And as I say, in this context, it is important that there was an explicit representation from the JJC registrar 8 days before the DIFC stay was agreed to, that the JJC petition was under consideration. And at this point, I think it would be helpful to look at Mr. Bajmal's statement, which is at D/5, page 253. And it's paragraph 32D. In fact, if we start at 32A, his firm had emailed the JJC Secretariat seeking clarification of the status of the petition on the 13th of July and on the 22nd of September. And the Secretariat at that time has said the petition had not been considered before the JJC. And then there was some further correspondence that passed. And then if we look down to D, on the 12th of December 2021, given the state of uncertainty surrounding the position of the proceedings at the JJC, he sought further clarification from the JJC Secretariat. As such, I attended the Secretariat's office during working hours. I spoke with the JJC registrar and sought to ascertain the progress of the JJC petition. I was informed that the JJC had in fact considered the petition prior to the submission of AIML's written memorandum of the 23rd of November 2021, albeit I was not told when. I expressed concern if the petition had been considered in circumstances, etc., where it had not been considered. So there was confusion about this, but he's being told it had been considered. The registrar explained that no decision had yet been made, but it was anticipated that such a decision would be made at the JJC's next meeting. And that then leads into the agreement of the order for a stay, obviously in the hope that that would lead in short order to a final determination of this issue. We also say that the position adopted by the respondents is inconsistent, because on the one hand, the respondents say that the JJC is functioning, but on the other, they say that we should have realised prior to signing this consent order that it was not functioning, and inserted some sort of different express wording. Miss Kitt, as you know, has given sworn evidence that at the time the consent order was signed, the applicants had a belief that the JJC was functioning, was a judicial body, and that it would have decided the petition in short order. That you will see is at D/3. And if we look in particular at paragraphs 28 to 30. So paragraph, it's page 176. The applicants agreed to the stay as an interim stay, and on the basis that the JJC position will be determined in short order. And then she sets out why. And then she says, had it known in paragraph 30, 60 months later, there was any possibility that the JJC would still not have reached a decision, the applicants would not have consented to the DIFC stay. The respondents criticise this evidence, and they say that she's merely asserted this. No source is given for this assertion, little or no weight can be placed on it. We say that's not a fair criticism. The identified person who had that belief is Ms. Kitt, acting as the applicant's agent, and it's difficult to see how that could be evidenced except through the sworn evidence that the belief was held. And as I say, even if this was a contract, there would be a good case for an implied term that the stay would not stay in place indefinitely if the JJC ceased to function. And as you can see, everyone is working on the basis that it will shortly thereafter make a decision. Third point, there's said to have been good consideration for the agreement. So in paragraph 49, the respondents say that both parties received something of value under the DIFC stay. We say that can only be true in a very limited sense. Each party got a stay of their claims, but then that's going to be true of any case in which the parties agree a procedural order. It is also correct to say that we did receive payment of our cost orders, but obviously those would have been payable in any event because they were court orders which KPMG were bound to pay. Fourthly, KPMG has received what it bargained for. It's putting it too high to say that lifting the stay means tearing up the parties' agreement. Indeed, we would say KPMG has to date obtained more than it bargained for, an indefinite stay of the claims, which the parties can only ever intended to stay on an interim basis. And then finally, we've got the liberty to apply provision, because the consent order did expressly retain the right to apply to the court. The consent order is at B/3, and if we can look, please, at page 127. That's where it starts, and at 128 is the operative provision in paragraph 4. This wasn't an ordinary liberty to apply. You will see that the words used are liberty to apply as to the implementation and the timing of the terms of this order. So there were two things expressly mentioned there, the implementation of the order and also the timing. So there's no sense in which this was a sort of permanent, come what may, compromise, such as the respondents described the stay as being. In effect, the respondents suggest that because of the wording of this order, that it should remain in place indefinitely. At what point would the court have any power to intervene and say, okay, now is long enough, the DIFC will now act? The respondents say that by agreeing to this stay, AIML knowingly took the risk that a decision would take some time. Well, to an extent that's accepted, but there's a world of difference between some time and 28 months, and indeed even more difference between some time and indefinitely. And likewise, there's a difference both of degree, so a delay of more than 2 years, but also a difference of kind. So the difference between the JJC being slow and no JJC decisions at all. The respondents seek to persuade you that the JJC remains a functioning judicial body. That's paragraph 59.3. There is no evidence of that before you, and we submit it would be wrong for you to accept in submissions alone when the parties have had opportunity to put in full evidence. Simply for counsel to say that it is functioning is not sufficient. That's even more so when you consider 4 other points. First of all, the JJC has not issued a decision since March 2021, which is 29 months ago. And that is set out in Mr. Bajmal's evidence. It's at D/5, page 252. That is not taken issue with, so it appears to be agreed. The respondents seek to say, oh, well, courts often take time to issue judgments, but that's beside the point. This is not just about delay, it's about the failure to issue any decisions in any case for more than 2 years. Secondly, the applicants, AIML, have made extensive efforts to obtain any information about whether the JJC is functioning, and all of those have come to nothing. And if we go forward to page 253 to paragraph 32 of Mr. Bajmal's statement, we have looked already at the reassurances given before the consent order was agreed. But if we turn over to 254, we see that then there were further efforts made, in particular at G, on the 5th of October 2022, AIML wrote directly to the chairman of the Dubai Judicial Council, requesting that he intervene and direct the JJC to decide the petition, and then obviously set out various factors, and you will see that set out there at page 255, there was simply no response at all to that letter. And then Simmons and Simmons also attempted to get Al Tamimi to agree something sensible, to ask for their consent or to withdraw that petition from the JJC. Again, there's been zero cooperation in that regard. We say it's irrelevant that the JJC registrar continues to accept petitions. That's set out in 31B of Mr. Bajmal's statement. So going back to page 252, the process of accepting new petitions, as he sets out, is an administrative exercise. It doesn't require the JJC as a committee to do anything. So the fact that they've continued to accept them doesn't show they're operating as a judicial body as opposed to an administrative entity. And then finally, it's said to be relevant that Decree 19 hasn't been repealed. Again, if you look at Mr. Bajmal's statement, he sets out at 31A, the fact the decree has not been repealed does not demonstrate that it continues to function. And there's an obvious reason for that, because obviously Decree 19 says that applications before the JJC must be determined within 30 days of filing. And that is obviously not being complied with. What will happen next? It's difficult to understand the basis for the opposition to the proposition that the applicants will suffer prejudice if the stay isn't lifted. We've addressed this at some detail in the written evidence and in the submissions, and I don't propose to go through all of this, but it is a matter of common sense. We've set out that there are various issues between the parties in relation to other proceedings. There are some proceedings between IGCF and KPMG in the Dubai Cour of Cassation and the Neoma Fund proceedings. Now, you don't have to concern yourself as to what the prospects are of those succeeding or not. But the point is that if those claims are allowed to progress and our claim remains stayed, then we will suffer prejudice. One point I should make is that paragraph 62(1), the respondents say that the IGCF judgment has been set aside. What has in fact happened is that judgment's been remanded to the Court of Appeal for reconsideration de novo. But we have not had any reassurance from KPMG that they have sufficient assets or insurance to meet all these ongoing proceedings. Secondly, in relation to evidence, again, it's a matter of common sense that the relevant evidence will degrade as time passes, the quality of it, and therefore there will be prejudice in that regard. We've set that out in detail at paragraph 20 of our skeleton. It's not really of any comfort that the respondents say they have a document retention policy. We don't have any details of that policy, and of course, not everything will be in a document. So there is going to be further prejudice caused if the stay isn't lifted. Thirdly, there's the issue that what appears to be argued for is apparently indefinite delay. And we ask the rhetorical question, if this court was to accept the respondent's position, under what circumstances could the stay in this order ever be lifted? What would happen if we came back in 1, 2, 3 or 5 years' time? And we say that the error of their arguments is to seek to elevate an interim stay into a permanent one, so that valuable claims are held in abeyance indefinitely, and the potential for abuse in that position, in that situation, is obvious. We say that would not be in accordance with the overriding objective, and the court's not bound to reach that conclusion merely because the stay was originally imposed with the agreement of the parties. I've set out for you in detail the circumstances in which that was agreed. So we say the stay should be lifted. The only thing that then would stop the court from lifting it would obviously be if there was a conflict of interest, conflict of jurisdiction within Article 4. And I know you are very familiar with this, with the difficulties of the translation. We've set the text out. I think that's using the Wilberforce translation at paragraph 24 of our skeleton. But in essence, what you're looking at is that is there a dispute where, and these are the crucial words, both courts have claimed or disclaimed jurisdiction, or whether courts have issued inconsistent decisions on jurisdiction. Now, I don't think anyone has said there are inconsistent decisions on jurisdiction. We have the DIFC decision. We don't have a decision on jurisdiction from the Dubai court. In terms of what the test is, we say the useful place to start is to look at the DIFC investments case in this regard. That, if we can look at it, is at F/14. And that's obviously a decision of Justice Sir Jeremy Cook. And I want to start at 16. So that should be, well, in fact, let's start on, let's start at 16, which is on page 870. So you will see at 15, there's the quote from Lacan setting out that you can have a conflict either through inconsistent judgments or through both courts maintaining or declining jurisdiction. Then these words, maintaining or declining jurisdiction over a claim, must be something less than judgment on the substance of the claim. Conversely, and this is important, mere existence of proceedings with the same claim in both of the courts cannot be enough. So those are, again, two ends of the spectrum. And then in paragraph 16, Mr. Justice Cook says that the court there in Lacan was drawing a distinction between commencement of proceedings in which the court was asked to exercise jurisdiction and some step in the proceedings amounting to a relevant decision to exercise jurisdiction or refusal to take such steps in order to constitute a maintenance or declining of jurisdiction. And then he goes on to say this, which is the important part. All the translations of the decree require a positive act on the court's part, with it making a choice on an occasion where it had to decide whether to exercise jurisdiction or not. It appears to me there can be no claim or disclaimer of jurisdiction until the court makes a positive decision that it either has or has not jurisdiction over the relevant claim. And then if we also look at paragraph 17, again, he goes into the facts of this case where no point was taken with jurisdiction in the DIFC. And then he says at the end of paragraph 17, as the existence of concurrent proceedings cannot amount to a conflict of jurisdiction, until this court makes a decision on jurisdiction per se, which is inconsistent with the decision of the Dubai court or delivers a conflicting judgment on the claim, there is no relevant dispute to be referred to the JJC. So if we just turn back in that judgment, we will see at paragraph 5 what had happened there. It's page 868. Was there'd been proceedings commenced in onshore Dubai, and then that was in January 2022. In March, if we look at the last sentence of paragraph 5, on the 1st of March, the Dubai court appointed an expert to consider the facts. And then paragraph 7, on the 18th of May, the onshore Dubai court gave judgment in which it concluded it did have jurisdiction over the claim before it. Now, that is important for a number of reasons. Firstly, because despite that decision in the DIFC, because no one had objected to jurisdiction, it was felt that there was no conflict at that point. The second point is that the respondents in their skeleton suggest that the Dubai onshore court only ever decides jurisdiction at the end of a case. Again, that's not correct. This was an example of a case where the Dubai court gave a specific jurisdiction judgment. So there must be a positive act in relation to jurisdiction. and that positive act, must be an unequivocal one. And here we go to one of your decisions, 5 Holding, which is at F8. And if we can look at page 0790, paragraph 51 of your decision in that case.
Yes.
And there you set out that at the top of 51, no party has objected to the jurisdiction of the Dubai courts, and all parties to those proceedings have submitted to the jurisdiction of those courts. Of course, here there has been objection to the Dubai courts. This was the only case which we've been able to find since LATCAM where there's found to have been a conflict. But we say it's important to note from the outset that this was an unusual case because there no party objected to the jurisdiction of the Dubai courts. And therefore, you say at the end of 51, so at least in cases such as this, where both parties have submitted to the jurisdiction of a relevant court, if the other court is also unequivocally exercising jurisdiction by, as in this case, entering judgment, a conflict of jurisdiction has clearly arisen. That is not the situation that we have here, because here there is objection to the Dubai court having jurisdiction. Second point is that, as you yourself set out, there has to be an unequivocal exercising of jurisdiction in order for a conflict to arise. And it is very telling that this is the only case in which we've been able to find that there's been found to be a conflict. The test that the respondents suggest you should apply in our submission tries to rewrite Article 4. It's set out in paragraph 86 of their skeleton. And the proposed test is that the court should say there's a conflict where one court takes, and this is quote, takes a positive step towards resolving the merits. Now, that language is not to be found in the cases and is actually inconsistent with the outcome of many of them. Just to look at a few, in a number of these cases, the Dubai court has done much more than taking a positive step towards resolving the merits, and this court nevertheless held the Dubai court had not exercised jurisdiction. So if we can look at Lasia, which is at F13, this is quite a short and not fully reasoned report because it's to do with permission to appeal. But if we can look at 861 and paragraph 5, we can see that this was an attempt to appeal again from one of your decisions. And we can see there that what you decided is in the second sentence. In his decision of 7th September, Justice Wayne Martin decided that the Dubai courts had never determined that they had jurisdiction to entertain the defendant's claims, and that the objection raised to the onshore court's jurisdiction by the claimant had never been determined. The onshore court instead simply determined the merits of the defendant's claim, finding against the defendants without ever deciding the question of jurisdiction. And in fact, this application for permission to appeal was dismissed with indemnity costs. But we can see there that the fact that the claim had been dismissed on its merits was not sufficient to amount to a conflict. There had been no decision in relation to jurisdiction. And then the court goes on to say, in respect of the claim made by the then the court goes on to say, consequently, the judge at first instance, relying on the decision in the Court of Appeal in Lacan, held there was no dispute as to jurisdiction between the DIFC courts and the onshore Dubai, since this was neither a situation where the courts had either each claimed or disclaimed jurisdiction or issued inconsistent decisions on jurisdiction. The defendant's application to the Judicial Committee therefore had no basis in fact. And then if we go over to paragraph 6, 2 lines down, the Court of Appeal said it's plainly not enough for the Court of First Instance of the onshore Dubai courts to have dismissed the defendant's case on the basis that it had no merit, for it to be assumed that there's a conflict of jurisdiction between the court and the DIFC courts. So if dismissing a case on merit is not sufficient for a conflict to arise, when we come to look at the thing that is relied on here, which is appointment of an expert by the Dubai court, that's even further away from there being a conflict. Then again, just going back to DIFC investments and Dubai Islamic Bank, again, the judgment of Justice Sir Jeremy Cook assists here. If we look at F14, and if we can go please to page 871. And I've already referred you to the passage at the end of 17. The mere existence of concurrent proceedings can't amount to a conflict unless the court actually makes a decision on jurisdiction or delivers a conflicting judgment. So you can have either or. And then if we look at 18, you will see there that he made the point that in the DIFC, all parties had accepted that there was jurisdiction. So what he said was that although the Dubai court, you remember this is the case where the Dubai court gave a judgment on jurisdiction. So they said, we have jurisdiction. In the DIFC, no one objected to that jurisdiction. And so what Mr. Justice Cook said was that, well, until I actually issue my decision on substance, and that is brought into conflict, there is no conflict that engages the terms of the decree. That's what he's saying in paragraph 18. He says, should I make a decision which is inconsistent with the decision of the onshore Dubai court, the terms of the decree would then be engaged. But at present, at the time he was asked to decide that case, there was no conflict. And then he goes on to say, in the circumstances, the right course appears to me to be to determine the substance of the claim with whatever consequences that might or might not have in the context of inconsistent decisions. So that again shows why what the respondents are submitting to you about conflict doesn't hold good. To show you yet another case, F11, the Mashreq Bank case, that again is another decision of Justice Sir Jeremy Cook, and in particular, if we can look at F11 and page 842, please.
Yes.
Paragraph 7, setting out that it's neither here nor there, that there's been substantial discussion of the merits of the underlying litigation in the onshore Dubai courts, which have not yet determined their own jurisdiction, because such jurisdiction depends on a substantive issue, and then he sets out what that is. So he was saying that because that question hadn't been decided, the fact that the onshore Dubai courts have stayed or were staying the proceedings there is a point that didn't assist the defendants. I would also ask you to note that the applicants have tried to press the Dubai court to expressly determine jurisdiction, but so far the Dubai court has refused to do that at this stage. That's paragraphs 21 and 22 of Mr. Bajamal's witness statement. Again, I'll just show you those very briefly. It's D5, page 250. So you'll be aware on the previous page that the jurisdiction challenge was put in June 2021. And then we see, if we turn to page 250, paragraph 21, in July, Amal Advocates submitted a request to the judge presiding, requesting that the jurisdiction challenge be determined. And sorry, to correct something that I just said, they haven't refused to determine it. They've simply ignored it and pressed on. The important point is they haven't actually determined it. In July, we see at paragraph 22 that they determined that the onshore challenge would not be dealt with until the expert's report was submitted. So they know it's there. They know at some stage it will need to be determined. But what they've said is, well, we're not going to deal with it until the expert's report has been submitted. Now, it's that expert's report that is said to be, paragraph 87 of the respondent's skeleton, quotes, a positive step towards resolving the merits that leads to the creation of conflict. And our unchallenged evidence in response to this is in Mr. Bajamal's statement at 19. So just above where we've been looking, it actually starts on the preceding page. 249, second sentence from the bottom. In this context, it's worth pointing out that it's common as a matter of practice in Dubai courts for such jurisdictional challenges not to be dealt with as preliminary issues, but rather to be considered at the time when the court reserves the matter for a final judgment. It's therefore also common for experts to be appointed to establish the facts before the Dubai court adjudicates as to whether it has jurisdiction to hear the underlying claims. The appointment of an expert does not therefore indicate that the Dubai court has determined that it will exercise jurisdiction or necessarily involve the Dubai court considering the claim on the merits. In practice, the Dubai court may decide it has no jurisdiction at a final hearing, such that it's unnecessary for the Dubai court ever to adjudicate on the merits of the underlying claims. So that is the evidence before you. The respondents have sought to say that it's common ground that the Dubai court always resolves jurisdiction challenges at the end. That's paragraph 83 and 85 of their skeleton. That's obviously wrong. I've already taken you to a case where that didn't happen in the DIFC Investments and Dubai Islamic Bank case. It's also not what Mr. Bajamal says. He simply says that it's common, it's not unusual, that as a matter of practice, this is left to be decided at a late stage. And as I say, it is very striking that the respondents put in no evidence taking issue with Bajamal 1, and obviously Ms. Jabala, who has put in a witness statement, is an onshore lawyer. You don't have any evidence from anybody qualified in onshore Dubai saying that the Dubai court has accepted jurisdiction. The unchallenged evidence is that the appointment of an expert is a preliminary fact-finding step and one that does not necessarily entail an adjudication on the merits or does not entail an assumption of jurisdiction. The other point that's mentioned, but I don't know how hard it's pressed, is there's some reference made to the imposition of the stay by the Dubai court. If we look at that, it's set out in D/6, page 327. And in the second paragraph on that page, and again, the translations sometimes make it quite hard to make sense of this, but it said, accordingly, and whereas it is established in the papers that the subject matter of the request heard in the present case is the same as the subject of the requests of the case pending before the DIFC courts. Both courts, Dubai courts and DIFC courts, did not renounce the above mentioned cases despite their connection to one issue. So that is an example of the Dubai court taking a pre-Lacan position and effectively saying that the mere existence of proceedings is sufficient to give rise to the conflict. So in other words, they're ordering a stay because of the existence of the JJC petition alone. They haven't decided that the Dubai court has jurisdiction. They've simply referred that off to the JJC to decide. And we can test that by a couple of things. First of all, at the time that this decision was made, that it should be stayed, this was before your decision in the DIFC that the DIFC had jurisdiction. So important to think that at this time, they had nothing before them to show that the DIFC had said they did have jurisdiction. It was simply the mere existence of those proceedings that led to a decision to stay it pending the decision by the JJC. The evidence that you do have is that this is not an exercise of jurisdiction by the Dubai court. Again, the only evidence you have on this is Mr. Bajamal at paragraph 27, and that is D/5-251. Paragraph 27. He says, second sentence, the Dubai court's stay order did not provide any dispositive order rejecting the onshore jurisdiction challenge. So no positive act, no unequivocal act. The order does not make any decision as to whether the Dubai court accepts or refuses to renounce jurisdiction. For such a decision to be made, the court would have had to provide reasons for the rejection which are not found within the stay order or any other order issued by the Dubai court in these proceedings. And then if we jump to the last sentence, the Dubai court granted the stay order without ascertaining whether there was in fact a conflict of jurisdiction. So in our submission, that takes the respondents no further either. And that is not a positive exercise of jurisdiction. It is not an unequivocal exercise of jurisdiction. And therefore, in those circumstances, there is no conflict. If I can just say a brief word, because we're criticised for seeking an order in relation to costs. The reason that we made that application is for two reasons, really, and it's entirely in your discretion as to what you do about that. But obviously, we've been left in a position where the JJC is not functioning. If in the future, and we say this would be unlikely, the JJC does decide the petition and does decide it against us, that is not something of our own making. Through the original order, we sought to take a pragmatic approach and to seek to reduce rather than increase costs. It's a situation that's completely outside of our control. KPMG could obviously have withdrawn the JJC petition, but they refused to do so, particularly in circumstances where there is at least one claim that will be proceeding in the DIFC. We would say that to have a situation where it could still be fractured is unsatisfactory. But I accept that is an unusual application. This is an unusual circumstance. I suspect none of us could foresee that we would be in this position where the JJC has effectively stopped functioning. So I'm in your hands as to what view you take of that.
Well, the problem I have with that application this day is this, and that is that, of course, the discretion with respect to the award of costs is a wide one.
Yeah.
It's generally exercised at a time when all the facts and circumstances are known.
Yeah.
I can see on the one hand your proposition that you are justified in pressing this case on in all the circumstances. I can see that there might be an argument to the contrary, to the effect that if you want to press the case on in a circumstance where there is a risk that the costs will be thrown away, then you take that risk. The question, I think, is whether now is the right time to decide those competing contentions. I think the answer, my tender view, is that it's better to decide that issue when all the facts are known.
That's understood. And in those circumstances, you know, my instructions are not to press that. I think it was something that that we wished to do to make the point and to perhaps urge KPMG to reconsider the position that they're adopting. But I entirely accept that it may be a better time to decide it further down the line. But those are my submissions on the substantive points, unless there's anything further I can assist you with at this stage. Thank you,
Ms. Day. Mr. Montague-Smith, before you start, as you may have seen, I'm having some technical issues here. I wonder if we could just have a 5-minute break while I try and sort those. I'm running out of power in one of my computers and I need to try and restore that, or one of them will drop out. So perhaps if you just turn the cameras off for 5 minutes, I'll turn mine off as well. As soon as I'm ready to go, I'll turn my camera back on again.
Thank you.
Okay, thank you. Okay. Good. Thank you. I'm very sorry about that. I'm sorry about the interruption. But anyway, both computers are working now, so we're ready to go. Mr. Montague-Smith, over to you.
Very good. Thank you, Your Honour. As my learned friend says, there's effectively two parts to this. So there's the question of the effect that there's a consent order in place and what impact that has on your decision. And then secondly, there's this issue of the conflict of jurisdiction. So I'm going to address them in the same order, if I may. And just on the first part, just to summarise where we're coming from, the first issue is, as my learned friend says, what is the test, or how do you go about deciding whether to set aside what is an agreed stay? And we say in relation to that, it is important that this was a contractual consent order. It was reached as a result of a negotiation which led to both parties giving something up. And the result of that was for a stay, but not just any stay. And it seems to me that while there is a difference between the parties about the test that you apply, actually quite a lot of the difference stems from the characterisation that we place on the order that was actually made, because this was a stay of a particular kind. It's the context that is important. That is, we do say it settled off, in effect, the defendant's prospective application for a stay under the JJC decree. But secondly, it was a stay for a defined period. And the fact that we've reached that by way of a contract, we say, is a very powerful factor to bear in mind when deciding whether to lift the stay. And my learned friend relies in her skeleton argument on general authorities about imposing and lifting case management stays. And we say that those are nothing to the point, largely because you are dealing with an application which requires the variation of a prior order entered by consent pursuant to a contract. Then the second part, and I'll explain that in more detail. The second part of that issue is then, well, once you've resolved on the approach you take to this sort of application, do the circumstances of this case justify lifting the stay? And we say no. You can't do that. My learned friend says she doesn't even need to establish a change of circumstances, and we say that must be wrong. But if that is the sort of lesser test, then that is not met either, because effectively what my learned friend says is that firstly, the basis on which the stay was agreed was that the decision would be made in short order. We say actually the evidence isn't good enough on that, and certainly there's no evidence of any common intention to that effect. But in reality, when you get to the date of the order, by January 2022, the claimants just must have known that there was at least the risk of considerable period of time passing before a decision came out. So as to prejudice, one has to look at the prejudice to both parties of firstly maintaining and secondly lifting the stay. And we'll go on. I'll go through the factors that are relied on by my learned friend, but we are a long way after the facts, and we're quite a long way, even if you start the case again today, from a decision. And the idea that there is any realistic prospect of degradation of evidence, for example, in that as a result of that intervening period is we say unrealistic. But you also have to look at the other end of the spectrum, the other side of the equation, which is that if you lift the stay, what are we left with? We are left with a situation where these proceedings will progress and the Dubai court proceedings will remain as they are, stayed until the JJC decision occurs. We're not faced with a situation where, for example, the JJC has been dissolved and we know that it is still accepting petitions, and this court comprises half of the membership. So it would be quite surprising, we say, if this court was to say, well, the JJC is just too slow. And if there is some other problem, some deeper problem that leads to the prospect of it not producing decisions at all, which is not the way the case is put, then this court we would expect to know that. My learned friend says we haven't got any evidence of that, but what evidence could we realistically get? The DIFC court's judges are inside that body and have the best information. We don't have any information about that. But ultimately, we say the parties had a dispute about whether, following your Honour's decision on jurisdiction, the conditions for a stay under the decree were satisfied. There was an argument about that, and that was compromised. And in course of that, the claimants extracted additional concessions on costs. So the court should be, we say, very slow to interfere with that, and leave the parties with the mismatched situation between the courts. So then that's the shape of what I say on the first part. And on the second part, we say, well, even if you get there, the claim does fall to be stayed now anyway, because the conditions for stay are met. This court has decided it has jurisdiction, and the Dubai courts have taken steps to determine the merits, and then they have stayed their proceedings pursuant to the judicial body decree, and that, we say, is sufficient to amount to maintaining jurisdiction. My learned friend took you to some authority, largely decided by Justice Sir Jeremy Cook, which takes a different approach. There are two lines of authority. You've been shown one. I'll remind you of the other. I'm sure you're aware of it, which takes what we would say is a more nuanced approach to the decision, and says in terms that you don't need a decision on jurisdiction from both courts to amount to a conflict, an express decision on jurisdiction. You can have something less than that, and we say in this case we have something less than that, and we prefer and suggest you should prefer that analysis, that more nuanced approach. So I'm going to deal with the facts and the issues in that order, if I may. But first, I was just going to remind Your Honour of how this stay came about very briefly. You've been shown part of the correspondence that led to it, but I'll just show you a little bit more, if I may. And just to place it in context, Your Honour decided jurisdiction issue on the 3rd of November 2021, and then what's happened is that the defendants have applied for permission to appeal against that, and that's ground to a halt. That was on the 24th of November, and then on the 16th of December, if Your Honour goes to page 220 of the bundle, it's behind tab D4, you see my instructing solicitors write to the claimant's solicitors proposing a stay. It's about halfway down the page. They say KPMG has lodged its appeal and its appeal skeleton because it needed to protect its position in the DIFC. However, KPMG LG's primary position is that there is a conflict of jurisdiction requiring the DIFC to stay its proceedings, and then asks for a consent to a stay of its claim against KPMG LG in the DIFC court under Article 5 of the decree. So there's no doubt that that is the scope of what is being compromised. It's a proposed application for a stay pursuant to Article 5 of the JJC decree, and then you've been shown this, but just to remind you, page 222 is the response that comes back. Paragraph 2, it's right that the claimants say our client does not accept that there is a conflict, but then they go on to say, without prejudice to that position, our client considers that it is for the JJC at this point to determine whether or not there is a conflict, and so on. It says our client is willing to consent to a stay of its claim alongside the existing stay of LCLD's claim, which is to remain in place so that the claims can still proceed together. And then paragraph 4 is important because then the claimants propose conditions to this agreement. The stay will take effect once your client has A, paid the costs that were ordered and assessed at 180,000. That's when a friend says, well, we would have had to pay that anyway, but B, agreed and paid our client's costs of your client's 17th November 2021 application granted by Sir Jeremy Cook, and which we calculate to be £7,826.50. Statement of costs is enclosed. So the position at that stage is that Sir Jeremy had ordered costs but not assessed them. And so what was happening here is they were proposing that the defendants agree to pay them in the sum that was being claimed, and then you get a negotiated answer, which is on page 224. They refer to the letter I've just shown you, and then second paragraph, subject to the terms of the consent order enclosed, the first defendant agrees with the claimant's proposed terms of the stay of the proceedings set out in your letter. And you'll see in paragraph 1, they've negotiated down the costs to £6,500, and we understand this sum is agreeable to the claimants. So there was a compromise of that issue, the quantum of the costs. Then there's discussion of the timing of the payments and when the stay would come into effect, and then a draft order is provided. And so what you have is a compromise, part of which is the stay order that was agreed. You then get the stay order itself, which you can find at page 128 of the bundle. Starts at page 127, but the operative provisions are at page 128, and the critical part, of course, is paragraph 1, which is that it says, until a final determination of the first defendant's application to the Joint Judicial Committee, the first claimant's claim against the first defendant, including the first defendant's appeal of the jurisdiction judgment, is stayed. So that's the critical issue. So it's not a stay in general terms. It is a stay until a defined event occurs, which has been agreed following negotiation. It's a clear compromise, we say, not only of the proposed application for a stay under the JJC decree, in light of the jurisdiction conflict we say now existed, but also of the quantification of a pre-existing costs liability. And my learned friend says this is not a compromise of an issue. The issue being, is there a conflict of jurisdiction? Why not? Because there was no concession given in that letter. But that's irrelevant, because claims are often compromised without admission of liability. The point is that this is no different. This is settlement of a proposed application for a stay. So that's where you get to, and the costs were subsequently paid. And we say that's a contract, and we've performed our part of that by paying the costs. So we do say it is fair to describe what is now happening as the claimants resiling or seeking to resile from that contract. They don't say that contract can be set aside. They don't say the facts get them to the threshold of terminating that contract. And unless paragraph 1 of this order is varied, then the stay cannot be lifted. My learned friend refers in part to
why can't it be lifted? Why can't it be lifted pursuant to paragraph 4 of the order that your client consented to?
Paragraph 4 provides the parties have liberty to apply as to the implementation and timing of the terms of this order. So what that is saying is just in relation to the implementation of the order, yeah, which this has got nothing to do with, because implementing the order is just bringing it to effect.
But what about the timing? The timing of the order, there are 2 times referred to in the order. One is in paragraph 1, where the period for the stay is until final determination, and the other is in paragraph 3, which refers to the recommencement of the, if you like, the permission to appeal proceedings. So why wouldn't the timing of the order timing of the terms of the order relate to each of those 2 paragraphs?
Because the provisions of Article 1 or paragraph 1, which deal with when the stay lasts until, is not related to the timing of the terms of this order. The timing of the terms of the order.
The timing of the order is for a stay until a defined time.
Yes.
And why isn't that liberty to apply with respect to the timing of the order?
Well, because clearly the indication in paragraph 4, we would say, is related to the 21 days that is provided for in paragraph 3, because if you say that it's simply an application for liberty to apply as to the timing of the length of the stay, then you are literally saying that what could have happened is that on day 1 they agree this order, they get the cost benefit that they get, and then day 2 they just can come back and say, well, actually we changed our mind. We changed our mind about the time, about when this stay is going to last until. And that would, we say, be a very surprising construction of that order.
Well, it would be difficult to do it on day 2. But the other point is that this is an order.
Yeah, go on.
Yeah.
I was just going to say. I'm sorry. It's very difficult on video, as we know.
You go.
No. Sorry. I was just going to. You'd say it's difficult to do it on day 2, but one has to then ask oneself, why is that the case? Because we say that is because, I mean, on day 2, if they came back and said we need more than 21 days, that would not be difficult to do. But the reason why, the underlying concern of doing it on day 2 informs the answer as to what the order means, which is that it doesn't mean you can just come back and say, actually, we've agreed to this in terms that the stay will last until the JJC petition is decided, but then come back and undermine that. Sorry, carry on.
Well, except that a stay order is an order of a particular kind, and I referred to that in Credit Suisse, where I said that a stay is, if you like, a case management order. There is no onus to set it aside. Of course, we have RDC 4.7, which provides express power to revoke an order that's made, and of course, we've got the inherent power of the court in relation to stays as well. So, if there is a contract, why wouldn't it be on the basis that the parties agreed to consent to this order, but in the knowledge that there were powers available to the court to either vary or revoke the terms of the order in appropriate circumstances, that being a matter for the court to decide. So in other words, isn't there force in Ms Day's argument that you're seeking to construe this order as being utterly inflexible and not vulnerable to the powers of the court to vary this order, powers which aren't really in doubt?
No, I don't take that approach. I think it's pretty clear from what our submissions are that we do accept that the court has a power, but we have a difference as to the circumstances in which it should be right for the court to exercise that power. I think that the way in which, and I'll take you through what we say about the authorities, the way in which the court ought to look at these sorts of orders is to give effect to the terms that have been agreed on the face of those terms. So the term that has been agreed is that until the final determination of the JJC petition, there shall be a stay. Now, that is different from those other cases in which you have decided that a power to impose a stay includes a power to remove a stay, because in those cases, the stay is not confined. It's not. It isn't the situation that the court has said this stay will last until X. The other point I would make is that I don't accept that this is just a case management order. There are different types of stay. So one can stay, in the most extreme case, very often, a compromise of a whole action is affected by a stay, and then you have a Tomlin order which exhibits the terms of that stay such that you can only bring the case back into action for various limited purposes. You can't just then apply generally to lift that stay. That's not a case management order. Similarly, in forum non-convenience type circumstances, the court can decline jurisdiction in the way that it would normally, or decline to exercise jurisdiction. The way it would normally do that is not by dismissing the claim, but by staying the claim. And so it's not right to say that every stay is the same sort of thing. And it's not right to say that this sort of stay, we would argue, is in fact a case management stay. But perhaps I can come back to that once I've put that in context.
Certainly.
But we do say that the effect of seeking to lift the stay and advance the proceedings before the JJC's determination would amount to an infringement of what has been agreed, because that is what paragraph 1 says in terms. So the old law in England was that the parties were simply held to their contracts in this regard. And that obviously changed with the introduction of the civil procedure rules, which is similar to the rules that we have introduced. And my own friend says that a ROPAC is no longer good law. I'm not sure we accept that the Court of Appeal has gone that far. It's certainly been refined and explained, but I don't accept that characterization that it's been effectively consigned to the dustbin. But if I may, I'm just going to show you some very short passages of that, then of Weston, and then come on to the Pernoni case. Yeah. So if we go to page 952, and at the foot of the page, this is Mr. Justice Neuberger as he was. He says, first, at least at the bottom of the page, first, at least in general, if the order was a genuine consent order that is representing a contractual agreement between the parties, and stated that if a party did not do something within a specified time, then his claim or defence would be struck out, or there would be some other sanction that represented a contract with which the court had no power to interfere, save in circumstances in which the court has power to interfere with a contract. And that seemed to be the effect of certain judgments, albeit he goes on to describe certain other circumstances where the court perhaps could go behind a consent order. And then he goes on later in the sort of 2/3 of the way down the page. He says, we have a discussion about consent orders should be clearly understood by the profession. But when an order is expressed to be made by consent, it is ambiguous. There are two meanings to the word by consent. One meaning is this: the words by consent may evidence a real contract between the parties. In such a case, the court will only interfere with such an order on the same grounds as it would with any other contracts. The other meaning is this: the words by consent may mean the parties hereto not objecting. In such a case, there is no real contract between the parties. The order can be altered and varied by the court in the same circumstances as any other order which is made by the court without the consent of the parties. In every case, it is necessary to discover which meaning is used. Does the order evidence a real contract between the parties, or does it only evidence an order made without obligation? And then he goes on to say, fourthly, in order to determine that, you may have to look at the correspondence. On page 95, sorry. Yeah, and under the heading fourthly, he says, in order to determine the question whether it was, so he defines the distinction as whether the consent order was genuinely a consent order in the first sense, or merely represented a case of the party against whom it was made bowing his head, and then refers to the Sieb Gorman as opposed to being a negotiated conclusion. And then on page 954, I won't go through it in detail, but he does talk about in the present, where he talks about in Sieb Gorman, for example, it's the bottom of the second paragraph, 4 lines up from the bottom. Talks about Sieb Gorman, the parties were negotiating the terms of the alleged consent order at the door of the master's room, and it was fairly quickly agreed. It was a fairly quickly agreed order in those circumstances. The Court of Appeal had comparatively little hesitation in concluding that the order in that case was the second type. And then in the present case, I've seen correspondence and attendance notes that that it was more of a negotiated conclusion. And at 955, you get to the first main paragraph there, which I'm sure Your Honour can read. But in effect, he says in the middle of that paragraph, the court has greater power to interfere than before. However, said that, I should add this, where the parties have agreed in clear terms on a certain course, and while that does not take away its power to extend time, the court should, when considering an application to extend time, place very great weight on what the parties have agreed and should be slow, save in unusual circumstances, to depart from what the parties have agreed. So then you have this being picked up by the Court of Appeal in the Weston case. You find that at page 1016. And I'm not going to take you through all of this in the interest of time, you'll be glad to know, but in Weston paragraph 24 we're in on page 1016, and around little a, there's a reference to ROPAC. Neuberger J held in a nutshell that even when parties have come to a consent order, in that case on an extension of time, there was an exceptional jurisdiction whereunder the court could still extend time, in my judgment. Wherever the jurisdiction comes from, and it could come from the liberty to apply in this order, the court must be very careful in exercising a jurisdiction to vary the terms of an order which represents a contract between the parties. And then paragraph 25, second sentence, I'd accept that the court should accede to an application for variation where it's just to do so. So that's really the test. But in my judgment, one of the aspects of justice is that a bargain freely made should be upheld. And then Mr. Weston clearly obtained benefits under the order of 23 January 2003. It may well be that those benefits are not as great as he thought, but that is not a matter for this court. In these circumstances, I do not consider it be right for this court to exercise jurisdiction to vary the order as sought. And what my learned friend says is that the effect of the Pannoni decision is that all of this, or at least the ROPAC decision, is really gone under the bus. We, as I say, don't agree that it goes that far. I think I would accept that Pannoni is a development and a refinement, and establishes that there are no hard lines. There's no jurisdictional test, but nevertheless, the fact of a contractual agreement, if it's right that that is being breached or is not being respected by the application to vary, it is a very powerful factor in favour against varying the order. The real issue, and I think my learned friend contended for this distinction, is whether or not the parties have reached, on the one hand, a genuine contract, or on the other hand, simply a procedural accommodation. That's the distinction that's identified in Pannoni at 1029. And it's on that page, if you've got 1029.
Yes.
It's a G on the right-hand column.
Yes.
There was an argument in that case as to whether the consent order was a real contract or simply a procedural accommodation which amounted to no more than an agreement, that an agreed draft order would be put before the court for it to decide whether to make the order. And it's clear that the nature of the order that is being agreed is, of course, also relevant. But even where you're dealing with a case management order, if I can just ask you to go back 2 pages, page 1028.
Yes.
And C, the Court of Appeal, even in Pannoni case, says it would no doubt be rare for the court to decline to give effect to the parties' subsequent agreement to extend the time within which some step was required to be taken by the terms of their earlier consent order, and thus to relieve from the sanction specified, but that the court reserves to itself the power to do so is entirely consistent with the court's general powers of management. So it's really a difference, as I say, on the test of emphasis between us, it seems to me. Once you have to decide, is this a genuine contract or simply a procedural accommodation? And if you accept it's a general contract, but even the, and the nature of the order is relevant, but even if you decide that it's just some sort of lesser agreement, that is still a powerful factor, we say. And so I would disagree with my learned friend's characterization of the law on that. I think she said that the fact of a consent order, if it is a procedural accommodation, would be of limited weight. We would disagree with that. But in any event, we would say that this is at the other end of the spectrum. My learned friend has already referred you to a passage of Zuckerman where the editors say that it can be quite difficult to draw the line. And the reality is probably that there isn't a hard line between those sorts of orders. But the point in this case is that the order that was made resolved the parties' rights. So it was not a case management order, we say, in the sense of an order determining the way in which the court will make a decision. It's not about the steps the parties need to take to prepare the case for decision by this court. It was finally determining, in effect compromising, the question of whether this court can make any determination at all pending JJC decision, and also compromising a cost liability on the side. So it's not case management in the sense of some discretionary decision that would otherwise been made by the court. The position for the court, if the application had been made, would have been binary. So if the claimants had conceded, for example, put it like this, if the claimants had conceded that there was a conflict, the court would have stayed the case and then there would have been no prospect of the claimants coming back to seek to try to reopen the issue and lift the stay, unless they could show that something had changed in the interim, which had an impact on the test. That is the test for lifting the stay or imposing the stay. In other words, if we'd had a hearing on this and the court had made a decision on it, then this application would not have been possible. Why not? Because nothing material has changed since then which could have any impact on the test for the stay. What's being said is there's delay and there's prejudice and so forth, but that does not form part of the test under the decree for imposing a stay. So my learned friend would have had to come back and say something has changed, which means you can reassess the question of whether the test has been met. And so if that is the situation, we would say, well, the same should be true if that prospective application is compromised in the way that it was. Why? Because otherwise you're going to end up deterring parties from actually settling off these sorts of things. Because this is not a situation where you're saying we need another 3 weeks to do something. Give us 3 weeks and we'll put it in a consent order. And then the other party subsequently comes back and says, well, actually, I now need more, or now you can have less. This is a situation where we were asserting a legal right or a legal obligation on the court to stay, which would be determined by investigation of the facts and the law, and that was compromised. So we do say that this is not a case management stay. It's a binary decision that the court would otherwise have had to make as to whether the relevant conditions arose. And that's why we say it's more akin to a stay in favour of arbitration or a stay on forum non-convenience grounds than it is to a case management. It's in that sort of category because it's not about managing the case, we say, at all. And so there is a right, a disputed right that was settled off by that consent order. And where there is a genuine contract which resolves a disputed right, we say that that is a very powerful factor, because the result is that you're inviting the court to tear up a contract. You're depriving one party of the benefit of that bargain. And in many cases, including this one, you're allowing the other party to keep the benefit they received. We do say that issue of whether or not there is a true contract, as my learned friend characterised it, could well be affected by the application of DIFC law to this issue rather than English law, because my learned friend said, well, there wasn't, I mean, I think she was challenging in effect that there was any consideration given, because she was saying, well, those cost orders would have had to be paid in any event. We disagree with that because the quantification had to happen and had to be agreed. But in any event, DIFC law doesn't require consideration. All you need to get to a contract under DIFC law is acceptance of an offer. It's a separate code, it's a different code. There are no other formal requirements to contracts, and we know that other common law doctrines generally are not imported into DIFC contract law through case law that's been decided recently in the DIFC Court of Appeal. So if anything, we say the resolution to hold parties to their contracts should be more strongly respected in this court, even than in England. And so when my learned friend relies on, in her skeleton argument at least, on cases about the imposition or lifting of general stays, those are nothing to the point. So, for example, there's the reference to Zumax Nigeria, but that was a stay imposed by consent, and it was in very different terms because it was stayed expressly until further order or agreement. I don't need to show it to you, but it's page 852, paragraph 5, that particular judgment. So there was never any question of varying an order, and there was never any question of going behind the parties' agreement. If you're with me, that the stay in this case is until final determination of the JJC petition. And the other cases that are relied on are Athena Capital. But again, that was a different sort of stay, and that was about whether a stay should be imposed on case management grounds, which is very different to this one. The case I think your Honour was referring to was the Credit Suisse case. But again, we say that is very different, because the point there was that where a general stay is imposed, there may be circumstances in which it can be lifted. but so a stay in ball terms doesn't preclude an application to lift the stay. But here we say the order provides in terms for when the stay is to be lifted. And so we say that the present case is different from those sorts of cases where you have general case management type stays for a number of different reasons. You have a contractual agreement, you've got a defined endpoint to the stay. And as I say, on the claimant's case, that they could agree this order, get the benefit of the costs concessions, and then turn around the next day and say they change their minds about that, and then apply to lift that stay. And on their case, the existence of the consent order just makes no difference at all. They don't have to show a change of circumstances. They don't have to show any kind of exceptionality. They don't have to give really any weight at all to the fact that a stay was agreed by consent. You just fight the issue out afresh. That's the effect of my learned friend's submissions. We say that cannot be right any more than if you concede, in effect, an application or a proposed application on forum non-convenience grounds and agree to a stay following that, you would not then be able to come back and say, well, actually, a few years later, I think that stay ought to be lifted. So we do say in circumstances such as the present, you do need something exceptional. I don't say that's a rule of law, but I do say you would need something exceptional to overturn the party's bargain in relation to this. And
well, why isn't delay of this extraordinary magnitude exceptional?
Well, it's the consequences that one has to look at. So the two factors that one has to look at are firstly that are raised against me are firstly that the basis on which they agreed to the stay was that the JJC petition would be determined in a short timescale or in short order. Now, I'm going to take you back to the evidence on that very briefly, if I may, because what we say in outline about this is firstly, they can't realistically have had that expectation given what had come before. And so if you agree to a stay order in circumstances where it looks like there's going to be substantial delay, then you can't come back and say those are exceptional circumstances or those are circumstances which justify lifting the stay if it's foreseeable that that is going to happen. So the evidence that's relied on is from Ms. Kitt, page 175. Again, let me take you to all of it, show you the bits I want to. And it's paragraph 23. She says that the agreement was, last sentence, in light of the then anticipated short timescale in hearing from the JJC, and over the page on page 20, paragraph 28. The applicants agreed to the DIFC stay as an interim stay and on the basis that the JJC petition would be determined in short order. Now, our first point in relation to that is that it's not, we say, evidence that can carry any real weight because there's no mention. Firstly, there's no mention of that in the correspondence by which the order was agreed. There's no suggestion that the defendants shared this alleged belief. And importantly, Ms. Kitt does not, in fact, even identify who the decision maker was for giving this consent. She just asserts that it existed on the basis of various matters, which I'll come on to, which are set out in paragraph 29. So what there's no evidence from anyone that we know made the decision, and no explanation of Ms. Kitt's knowledge of what was understood. It's just assertion about what the applicants understood. Now, my learned friend has said in submission that the belief was Ms. Kitt's own belief, but she doesn't actually say that. She says the applicants had that belief. She doesn't identify who the individual persons were, and she does not even claim to be the decision maker herself. So this is really generalized submission more than actual evidence of somebody's subjective belief. And we say that if you look at the points that are relied on, it's not credible to suggest that those factors could have really led to the view that there would be some sudden decision. So the belief is set out at paragraph 29 is based on A, the applicants did not have any reason to doubt that the JJC continued to function and dispense with petitions. B, the registrar had indicated that the JJC was in the process of considering the petition. and C, the JJC decisions in other matters have been published on the JJC website in July 2021. And then the points raised, which are relied on as justifying lifting the stay, are then at paragraph 32. So you've got them A, B, C, D. And the point we make here is that if you go through each of these, in relation to most of them, those are circumstances that would have existed to a great extent prior to the agreement. So A, it said it's now almost 2 years since the petition. By the time of the order, that was already, since the petition was issued. By the time of the order, that was a period of already 9 months. So they must have known that these things were taking a long time. B, no JJC decision had been issued since March 2021. By the time of the order, that's 10 months already. There's reference to the pandemic backlog. I mean, that all appears to be inference. There's no direct evidence of that as far as we can discern. But even if it's right, the effects of the pandemic have been long been known since well before the order was entered. And then at D, they refer to efforts that were made to try to advance the position or understand the status, which had been fruitless. But those efforts are set out above at paragraph 20 on page 173. And virtually all of them were made prior to the order being agreed. Quite a lot of reliance was placed on things that are said to have been described orally to Mr. Bajamal in a one-sided conversation, which he said he had with the registrar. So we've got his witness evidence in relation to that. And we say very little weight can seriously be placed on that, or very little expectation could really be placed on that when the defendants were not involved in those discussions. So it's not in the presence of the defendants. It's just something said as an aside to somebody in a meeting that took place with the registrar. If there was going to be real assurances of progress or speedy progress, given what had come before, you can't rely on something that's said in those circumstances. It would have had to be set out in some sort of correspondence, or at least said in front of both parties. So the point of this is to say they must have known by this point that there was at least the risk that it would take a substantial amount of time for these issues to be decided. And the fact that the consequences have not been as the claimants have expected is not, we say, a reason to go behind their agreement. In relation to this, my learned friend says, well, she says I'm being inconsistent. I think she says because I'm saying that the JJC both is and isn't functioning. But that's not right. I do say the JJC is functioning. We know that because it continues to accept petitions. It is right that there have been delays in producing judgments and very significant delays. My point is that that could be seen both before and after consent order. So when they signed that consent order, they must have known about it or been expected to know about it. And so there's nothing inconsistent with what I'm actually saying in relation to this. The claimants, we say, signed up with open eyes to these risks. The other point that's made is they say, well, there's going to be prejudice if this delay continues, prejudice to them, they say. And the only possible relevance of this would be to prejudice going forward as a result of a continuation of the stay. And 3 points are made against me. First, it's said, well, it's all disrupting the liquidation. But that's really just to say that the creditors don't want to wait any longer, but their fortunes follow the company, which has agreed to this course. The second and third points are perhaps the more substantive points. Firstly, they say there's concern about the defendant's ability to satisfy judgments against it. And there was some evidence about a judgment that was against the defendant, one of the defendants, but has been sent back to the Court of Appeal for reconsideration by the Court of Cassation. So that's up in the air. But what is the prejudice in relation to this? Effectively, the claimants are saying, well, we might lose our place in the queue, or we might not get to judgment fast enough. But we say that that's just unrealistic, because we are, let's face it, probably years away from a judgment in this court, even if you start these proceedings now.
But the journey of 1,000 miles, starts with the first step.
Of course, I accept that.
And these steps have been delayed for a long time now.
I accept that. But I'm just dealing specifically with the prejudice that's alleged. And one is that if you continue the stay or don't lift the stay, there's going to be some discrete concern arising out of the claimants being unable to take their place in the queue as creditors if they succeed. And we say that in order for that to be real, that discrete issue, they would have to be a prospect of them catching up with those claims, which, by the way, have already been decided and have gone back down now to the Court of Appeal because they've been up to cassation and down again. So I agree, the journey is many steps, but those many steps are not going to get to a conclusion here in a way that's going to leave the existing cases against KPMG in the local courts being of any relevance at all to their ability. So I'm just dealing with the discrete prejudice that's alleged. You have to look forwards, and we say the same point arises in respect of the arguments on both of degradation of evidence. That's said to be a risk in relation both to witness evidence and also in relation to documents. We are dealing here with audits which took place in 2014, between 2014 and 2017. So we say it's simply unreal to suggest that there will be a material degradation of the quality of witness evidence, for example, at trial, which is 2 years or so hence from now. It's just not realistic to say that the quality as it is today, after X years have passed, will actually be significantly different from the quality it would be as a result of a stay remaining in place. And there's no actual witness that's been identified who is said to be material, is available, and whose evidence might suffer. On the documents, there is a document retention policy which has been in place and is being monitored by an international law firm. Again, one has to think, what is the prospect of documentation being lost as a result of continuation of the stay? And we say it's just unrealistic, given the passage of time to date and the amount of time it's going to take to get to trial, to suggest that that a stay would have any real impact on that. And we do say if you're going to if you're at the stage of considering prejudice, you have to consider the prejudice to both sides of lifting or of retaining the stay. And the effect of lifting the stay is you end up with a mismatch between the position in the Dubai courts and the position in the DIFC courts. So you end up with a situation where the Dubai courts proceedings are just stuck where they are, and the DIFC court proceedings continue. We do say that is a powerful factor, because regardless of how we got here, that is the position that we have at the moment, that both cases are stayed, and the effect of lifting the stay is to upset that balance and have one court moving on while the other one is not. So ultimately we say all of this was foreseeable when the parties reached their agreement. It doesn't amount, we say, to the circumstances which could justify departing from their agreement. I mean, one has to think through what would happen, for example, to the costs. Do we get to go back and reassess those? Presumably the claimants keep those too. There's quite a lot. Just see, I don't think I need to deal with that. I mean, yeah, and so the reality is, if you were to lift the stay, we say you upset the balance that was agreed and the balance that was affected by the order that was that was made. My learned friend asked the question, if not now, when would the stay be lifted? And the obvious answer is, well, when the JJC decides the issue, decides the petition. It's not said that will never happen. We don't know when it will happen, but it's not said. My learned friend doesn't go so far as to say one can infer that it's never going to happen. And if it was never going to happen, one would expect that the DIFC court would know about it. It's not a satisfactory situation, I accept that, but it's not one of my clients making. And the idea behind the stay was to implement what I will move on to discuss, which is the policy behind the stay provisions in the decree, which is to stop us having to litigate twice in two different forums. and stop us having to go through a whole rigmarole of litigation, which may have to be unwound. That's what I was going to say on the issue of the consent order, and whether you can go behind. We say you'd have to go behind it to look at the question of whether or not there was a conflict of jurisdiction. If you're not with me on that, we do say that there is now a conflict of jurisdiction, and as my learned friend has said, and I fully accept, your honour is well across the texts, but I do say that there are essentially two different lines of authority here. So Justice Sir Jeremy Cook, in more than one case, has said that what you need to establish a conflict of jurisdiction is an unequivocal statement from both courts that they accept jurisdiction in the sense of a decision on a disputed, contested jurisdiction application. We say that that goes too far. I mean, amongst other things, it means that the court does not, in terms, maintain or exert jurisdiction at all unless there is an objection to jurisdiction. So it's a rather odd construction in the first place, but I'll take you through that. But on the other side, there are the cases of Five Holding and the Credit Suisse case itself, which we've touched on in a different context, that make it clear that in those decisions, the view was that something less than a positive decision on jurisdiction was required. There is no court of appeal, binding court of appeal decision on this. My learned friend refers to a decision on permission to appeal in the Lassier case, but that doesn't actually take us much further. I'll just clear that away. There are two conflicting lines here. If we go to page 860, which is where there is that decision, you'll see that that is a decision on permission to appeal. So it is not, so you'll see on page 861, permission to appeal was refused. So it doesn't, there's no binding decision of the Court of Appeal in relation to this issue. There are just two streams of decision. Now we don't, I think, have the underlying judgment for this case. I think that's right. We can pick up some of the facts from paragraph 5 of that. But what we say about this is that these things are always fact sensitive. You turn on the facts as to what amounts to an exercise of jurisdiction or maintaining jurisdiction. So it is difficult, we say, to draw any conclusions from that. But put it at its highest, what we say is that this is simply another case which is reflective of the two different streams of authority that you have in how to approach the question of whether or not there is a conflict of authority. So on the one hand, there is a line of authority that says you need a positive decision on jurisdiction. On the other hand, there is a line that says you don't. And we say that the Five Holding and the Credit Suisse approach is the one that is consistent with Lacan, and Sir Jeremy's approach is not. And I was going to just address this briefly, if I may, by taking you through just one or two passages from, I think, 3 or 4 different decisions. And I know you know Lacan well, but just to remind you of one thing that was said in that, the point was made in Lacan that the decree contemplates two different types of conflict of jurisdiction. So it contemplates a conflict between existing proceedings, so proceedings conflict, and on the other hand, a conflict between different judgments. And so one of the points that was made in Lacan is that we have to construe this decree in a way which gives effect to both parts of that. The conflict between extant proceedings must be possible and different to a conflict of judgments. And as a result, something less than a judgment amounts to exercising jurisdiction. We can see that on page 766, which is an extract from Lacan, and we see that on paragraph 20, if you've got that in the bundle. You can see, firstly, the relevant, and I appreciate that there are different translations at play, but I don't think they necessarily matter in this particular instance. But you can see there the translation of Article 1, first of all, paragraph 20, which establishes Article 2 sets out the competencies and powers relevantly being 1, determining the competent court to hear a claim or application in respect of which there may arise a conflict, and secondly, determining the judgment that should be enforced in a case of conflicting judgments. So there are two differing missions, two different conflicts that can arise, and you see then the translation at paragraph 22 of Articles 4 and 5. Article 4, in the event that there is a dispute as to jurisdiction between the Dubai courts and DIFC courts, either where both courts had claimed or disclaimed jurisdiction, or where the two courts have issued inconsistent decisions on jurisdiction, the following procedure shall be followed. And so there are those two competing possibilities. And then if we go down, we don't need to read, I think there's reference to the different translations in the different language. But if we go down to page 769 of the bundle, paragraph 33.
Yeah.
In broad terms, and without at this point going to the different translations, the conflict of jurisdiction can be either through inconsistent judgments or through both courts maintaining or declining jurisdiction over a claim. So the Court of Appeal says it's maintaining or declining. That's what it means. And then says this is not an inconsistent judgment case, but dichotomy is of some importance. Maintaining or declining jurisdiction over a claim must be something less than judgment on the substance of the claim. And I'll come back to that in a moment. But we had understood the claimants to accept, and this may not be right, but we'd understood them to accept that the Dubai courts tend to decide jurisdiction and the merits together. Now, I think the evidence.
My experience is sometimes they do and sometimes they don't. I've heard a number of these cases, and in some of them, they have made a determination of the objection jurisdiction. Sometimes they haven't. Sometimes they just ignore it.
Right. My understanding is that generally speaking, the practice is that it comes at the end of the case. Now, there are examples where that hasn't happened. In fact, my learned friend suggested that the DIFC investment case was one of those examples. That's not correct. It says in terms that the merits and jurisdiction were decided together. That's paragraph 7 of page 868, but it doesn't matter. If it is right, as we suggest it is, that generally speaking, the Dubai courts decide jurisdiction and the merits together, then one of the consequences of requiring a positive ruling on jurisdiction is that in all those cases where there wasn't, you would rule out, in reality, the prospect of there being a conflict of jurisdiction in the proceedings. And so that first limb would become, in practice, somewhat redundant. And that, we say, one indication that that can't have been what was intended by that first form of conflict. Now, where the issue has arisen, it is, we say, what appears to have happened in these other cases, which say you do need a positive conflict, is that what they've done is they've gone to the end of paragraph 35, which you can find on page 770, and they've picked up the words at the end of that paragraph, which say there must be at least an occasion for deciding to waive or not waive, as is clear from the other translations. And that has been interpreted as meaning you need a positive decision on jurisdiction. But if we read on, as you will be aware, that is not what the Court of Appeal was saying, at least in Lacan. If one goes down to page 771 and paragraph 37, in Lacan you say it's unnecessary to decide in this case whether the step must be a decision on jurisdiction or whether it suffices that the court exercises jurisdiction towards determining the claim. So that issue wasn't decided in Lacan. And if we look at the decisions where the position has been adopted that you need a positive decision on jurisdiction, there's no real explanation for that approach. It's said to follow from Lacan. It doesn't follow from Lacan. So, for example, if we go to page 871, paragraph 16 and 17, you'll see it's really. So if you start at page 870, you'll see there's reference to the statements in Lacan. Paragraph 35 is then referred to at paragraph 16, you'll see. And then the conclusion comes at the end of paragraph 16, really. Last sentence, it appears to me that there can be no claim or disclaimer of jurisdiction until the court makes a positive decision that it either has or has not jurisdiction over the relevant claim. The case for the more nuanced approach is set out in the 5 holding case. So I'll just show you that very briefly and remind you of it. You'll probably, well, you may or may not remember it. 790 is the page that I'd like to show you. Right, very good. Well, I won't labour it then, but the point there is that Your Honour made took the point that you have to look at the policy behind why would you want stays at all, and so it's page 790, paragraph 49. About 4 lines down, the mischiefs which are addressed by the decree are the potential for conflicting decisions and the burdens imposed upon the parties by a multiplicity of proceedings in relation to the same dispute. Those mischiefs arise whenever both courts exercise jurisdiction over the same dispute concurrently, irrespective of the orders made in the exercise of that jurisdiction. Although the decree also deals with conflicting judgments, there can be no doubt that the JJT is empowered to act before that circumstance arises in order to prevent that circumstance arising. And then paragraph 52, I'll come back briefly to something else, but if we go 52, put another way, in a case where all parties have submitted to the jurisdiction of one of the courts, so that no occasion will ever arise for that court to rule on its jurisdiction, it would defeat the evident purposes of the decree to construe it as only applying if and when the court expressly rules on its uncontested jurisdiction. No party advanced that contention to the court. And that, we say, is a compelling analysis, because the purpose of having a stay is to prevent inconsistent multiplicity of proceedings, and that is the purpose by reference to which you have to construe the test for a conflict of jurisdiction. And so if you do it that way, then you have to look at whether or not that mischief would occur absent a stay, given what has happened in each of the courts. And we note paragraph 51, if you go back, one of the cases was one where there was a number of cases. Just in the middle of that paragraph, you can see that one of the cases was one where jurisdiction application had been made to the Dubai courts but had not yet been decided because the Dubai court case was stayed. We see that from paragraph 51. Now, this is the analysis that is ultimately supported by the Credit Suisse case. So if we go, for example, to page 811, we see at paragraph 47 reference to 5 holding, paragraph 48, it's unnecessary to repeat it at length. And then at the end of that, over the page on page 812, F, whether or not each court has exercised jurisdiction in relation to the same dispute so as to give rise to a conflict of jurisdiction which engages the jurisdiction of the JJT will generally depend upon the facts and circumstances of the particular case. G, a court will assess whether there is a conflict of jurisdiction in any particular case as a matter of substance rather than form, having regard to the evident objectives of the decree, which are A, to minimise the risk of inconsistent or contradictory judgments or decisions, and B, two, to avoid a multiplicity of proceedings with respect to the same dispute. So that's we say that the analysis that is to be preferred, and it is one that achieves the objectives of the decree. And if one thinks about it like this, the Court of Appeal has told us that the test is whether the courts are maintaining jurisdiction. So if that is right, in order to say that there is never any conflict until both courts have actually made positive decisions on jurisdictions leads to quite strange results. So the idea being that the court can actually issue a judgment, but at no stage has it been, quotes, maintaining jurisdiction. agree that that's a term of art, but it might be. But the Court of Appeal has expressed that phrase as being the meaning of what is required. So if that happens, you get some very weird outcomes. The question of whether or not the court is maintaining jurisdiction turns on what one party does or doesn't say, the issues that are raised in the case. So we do say it can't be right that can be the answer. And it does promote form over substance. Because on any normal use of language, you would say a court is exercising its jurisdiction when it makes a final order, gives a final judgment. And if that is right, then the test for maintaining jurisdiction cannot be deciding an express decision on jurisdiction, issue on jurisdiction. So if something less than judgment is required, the question then is what is sufficient? And that's always going to be a difficult question to answer in the abstract. And so it might be more useful to look at what has actually happened in the Dubai courts in this case. So if we go to page 265, what's happened is that, and I'll just take you through this very briefly, this is the judgment of the 30th of June 2021. The Dubai court has considered the claim and has appointed an expert. And you'll see on page 267, there's a general description of the claim, and then 267, a number of things happen for these. Do you see the heading for these reasons? And under that, the court rules in presence and prior to the adjudication in the subject matter of the case to appoint an accounting expert from the role whose mission shall be, and then to take various investigatory steps. But it doesn't stop there, because if we go over the page to 268, in the middle of the page, about a third of the way down the page, there are specific provisions in relation to the expert. The court permitted the expert, for the purpose of performing his mandated mission, to move to any location he deems appropriate, to peruse any documents that benefit in the performance of his mission, to hear the statements of whomsoever without taking oath, and it determined the amount of 20,000 dirham security amount and so forth. And then at the bottom of the page, the two parties of the litigation must submit whichever documents they may have to the expert in the session of the first meeting, and the expert must submit his report in the fixed session, and in the event of not submitting and so forth. So the parties are positively ordered to take certain steps by the court with a view to providing the expert with the means to assist in resolving the dispute. And this is clearly the substantive dispute, because at this stage there's no jurisdiction objection lodged yet. So I would suggest that it is quite hard to see how that is not maintaining jurisdiction. It's the court actually exercising its coercive jurisdiction, ordering the parties to do things.
This was before the objection to jurisdiction had been lodged.
Correct.
Yes.
Correct.
All right.
But I think that, I mean, does that affect the analysis? Not obviously, but because the two.
Well, I think it does characterise the question, because if there is an unresolved objection as to jurisdiction, then it does make it harder to argue that the courts has positively affirmed jurisdiction. So in other words, if there is an objection to jurisdiction and the court then goes on and exercises jurisdiction, then it's easier to characterise that as a step in the exercise of jurisdiction. But if this is a preliminary, as Ms. Day says, this is a preliminary step taken at a very early stage in the proceedings before the respondent, the defendant, had a chance to lodge the objection to jurisdiction, then it possibly puts a different character on it.
No, I don't accept that it was before the defendant had a chance. The defendant didn't attend some of these first meetings, and so there's a timing point in relation to that. But I wouldn't accept. One has to take it in stages. So the question is, at this particular time, when this order is made, is the court maintaining jurisdiction over the case? And the answer in those circumstances, we say, might well be affected by the question of whether there's an extant jurisdiction, because it's the other way around. Because if there's an extant jurisdiction complaint and the court is making orders, you know, it's open to a party to say, well, it's only exercising jurisdiction provisionally because it hasn't decided the jurisdiction dispute that it knows exists. Whereas at the time it's making these orders, there isn't even that jurisdiction dispute. It thinks it's just going on and deciding the case, and these are the steps that need to be taken to do so. So I would suggest it's the other way round. The fact that there isn't yet a jurisdiction objection means that this must be the court maintaining jurisdiction. Not only is it maintaining jurisdiction, it's exercising jurisdiction over the parties by making orders against them to provide documents. So it's not, I would suggest, I don't think it undermines my position. I think I would suggest it supports my position. It's not a very provisional stage. Yes, it's at the beginning of the case, as it would be. But it's clearly an exercise of jurisdiction. There's nothing to mitigate that. There's nothing to suggest that it's provisional, and there couldn't be because there isn't an ongoing jurisdiction application. And so, if one thinks back to the dicta in 5 Holdings, that is the right solution. The mischief that is addressed is precisely the burden of multiple proceedings. And so you can only address that mischief if you interpret the requirement for conflicting jurisdictions in a way which triggers the stay when that burden manifests itself. And it manifests itself when the court starts making orders like this, which is saying, right, get your documents out, and here's an expert, and the expert is empowered, by the way, to go in and look at anything he wants to and talk to anyone he wants to. I accept it's not a positive decision on jurisdiction, as I say, that's because the claimants haven't made that yet. So if the requirement is a positive decision on jurisdiction, as in the sense that there needs to be an application disputing which is resolved, then that has not been satisfied. But in relation to this, my learned friend says, well, you can't rely on much because we've got this unchallenged evidence from Mr. Bajamal about what you can take away from all of this. And Mr. Bajamal is the claimant's lawyer in Dubai. He's not an expert witness. He can tell you what has happened in the local courts, but he can't give you expert opinion as to the impact and importance of that. So my learned friend even suggested that Ms. Jabala was an onshore lawyer who could have responded to all of this. She's not an onshore lawyer, and she couldn't have responded to it because she's not an expert. So there's no. Mr. Bajamal oversteps. We don't make a huge point out of it, but you can't rely on him to tell you the meaning of Dubai court process. But the point is that when the jurisdiction objection came in on the 12th of July, after that, the Dubai courts stayed their own proceedings. And you see that at page 326. And we do say that this gives rise to an important factor when you come to consider this stage. So you will see that the basis on which they stayed the proceedings is, if you go to page 326, it is clearly the decree, and you see reference to the decree about halfway down the page on page 326, and they find that the test in the decree is satisfied. They don't go into the meaning of that test in the same way that Your Honour has, but they find on page 327, the second main paragraph, accordingly, and whereas it's here established in the papers that the subject matter of the request is the same, the Dubai courts and DIFC courts did not renounce the above mentioned cases despite their connection to one issue summarised in adjudicating. And so they have decided two things. One is that what has happened in the DIFC courts is sufficient to amount to meeting the test, and the other thing is that what has happened in their court is sufficient to amount to meeting the test for a conflict of jurisdiction. And the issue between the parties on this application is about the effect and the meaning of what has happened in the Dubai courts. That's the issue. And so the short point on this is that the fact that the Dubai courts have said about their own processes that the steps that they have taken amount to a relevant exercise or claim or maintenance of jurisdiction, the fact that they have said that about their own processes is a powerful factor in determining this part of the application, because it's one thing for this court to disagree with the Dubai courts about the effect of the stages of DIFC proceedings and what has happened to them and what that amounts to by reference to the decree. It would be quite something, we would suggest, for an international judge of this court, though, to disagree with them when they're describing the meaning and effect of what they have done in their own court system, to say, no, I know better.
But isn't it clear from the terms of their decision that they are taking a different approach to the construction of the decree to the approach taken by this court?
I don't accept that that is clear. They've certainly taken a different view. The point that my learned friend made was that they take a different view as to the impact of what has happened in the DIFC. That is true. And in relation to that, who is better than the DIFC to decide whether that is the case? But it's not clear that they have taken a different view about that. In fact, there isn't really any genuine explanation about all of this.
Well, and again, one never knows how reliable the interpretation is, but the proposition that neither court has renounced jurisdiction wouldn't, on the jurisprudence of Lacan and Lemire, that wouldn't amount to a conflict in this court.
But I think that is placing too much emphasis on the precise language that's used in the translations, because in effect what's happened in Lacan is you have interpreted judicially what is meant by the words, and that is what is going on there. I don't think you can take it from that they are applying a different test to their own processes about what is going on, and there's been conflicting backwards and forwards from both courts, frankly, about what is required for the test for a conflict of jurisdiction. And at the beginning, there were lots of very immediate stays, and subsequently there weren't, particularly in the Dubai courts. And now, in this case, they've taken the view that in this claim, that the test is satisfied. But we do say it's possible that they have taken a different approach to the legislation, but they are dealing with it's still quite something for this court to say you've got the meaning wrong of that legislation as applied to your own processes. It's an Arabic text issued by the Dubai ruler, and the effect of it is being interpreted by them. And so, as I say, I don't say it's necessarily determinative. Don't say you're bound by it by some res judicata, but it's quite something for this court to turn around and say, you think you're maintaining jurisdiction, but I don't think you are. And I'm told that, in fact, if it matters, if it comes down to the translation, I'm told that the sentence has not renounced is simply a translation of the Arabic text in Article 4. So it is simply it's effectively just saying they meet this test. They don't, it's right, go on and describe the test and what it means in the same way, justify it in the same way. But I don't accept they're applying a different standard to their end, if I can put it like that, of the question of the conflict. And it seems to me that if this court is going to be second guessing the Dubai court's decisions as to what its processes amount to, you are guaranteed to end up in conflict. It seems to me the only sensible solution is for each court to be deferring to the other court on the question of whether or not their end of the conflict is established. I can put it like that. Otherwise, you are bound to end up with a position where the decree has actually made things worse, not better. So the mischief that's...
I don't think there's any doubt about that.
But I mean, in practical terms, in relation to, well, no, I mean, I understand the sentiment, but one has to look at the purpose of the decree. What is the point of it? There's a real genuine point which has never otherwise been resolved in these courts, which is what do you do with parallel litigation? What happens? Is it just a race to judgment? Is that what it is? And the answer is, if it worked properly, the decree would be a solution. And the question then becomes, it is trying to prevent multiplicity, it's trying to prevent conflicting judgments. But if you interpret it, if you second guess the local court's decision as to what it is doing, you inevitably end up in a situation where one is being stopped, the other isn't being stopped, and it's just arbitrary. It's just totally arbitrary.
The problem is the decree has never worked properly because of the chronic delay in making decisions, despite the provision in the decree requiring decisions to be made within 30 days. So the authors of the decree appear to have realised that if the cases weren't decided promptly, it would create a vast incentive for people to commence proceedings in the other court and then apply for a stay until the committee had made its decision. And that's precisely what's happened. We all know that's been happening for 6 years now, and it's made a bit of a joke of the jurisdiction of the court.
Well, I look, I mean, I understand, and I do. I'm not really going to argue with you about the consequence and the way it's panned out. I think, though, my submission on that would be all of that is a very good argument for why the law needs to change, but we need to look at the law and to try to make it work as best we can. And what we can't do in the context of this hearing, or indeed in an interpretation of a statute, is speed up the operation of the JJC. Nor can we, it appears, even though one would hope the court has some insight into it, really get any better understanding into the operation of the JJC.
Yes, well, I don't have any insight. I don't represent the court on the JJC.
No, I understand.
The Chief Justice does, and I just don't know what's going on. But I will be writing to him after this case and trying to find out what on earth is going on, because
I'm
it's
sure
just it's making a bad situation a lot worse.
I understand that sentiment. I can see. I mean, I'm hesitant to criticise the legislator, but at the same time,
very dangerous thing to do, especially if you're in Dubai when you do it.
Well, yeah, it's all recorded. Yeah, I mean, I think the points your Honour is making go to the question of whether the law should change, not to whether or not to how it should be applied. Seems to me. But I do understand the sentiment, if I can put it like that. Yeah. Unless Your Honour, I'm just checking whether or not I need to say anything more on that. I take it from your Honour's comments and my own friend's points that I don't need to address the costs issue. No, I was going to say precisely what Your Honour said, but subject to somebody interrupting me, I think those are my submissions, or subject to any questions you have for me. Thank you.
Ms. Day, submissions in reply.
Thank you. I'll try and be as brief as I can. Dealing first with whether you have the power to lift the stay, it really is a staggering submission to make that you have no power to lift this because we agreed to those words in the order that are set out in paragraph 1.
I don't think that's quite how it's put. I think, in fairness, Mr. Montague-Smith, he doesn't say that I don't have power. He says that it's a power that should be exercised sparingly because it effectively involves setting aside an agreement reached between the parties. And this is not one of those cases in which the power should be exercised. Have I got that right, Mr. Montague-Smith?
Correct.
Yes.
Well,
right.
he does say that, but he then goes on to say that in no circumstances should you interfere with what the parties agreed in paragraph 1, because he says you cannot interfere until the JJC has decided the issue, the petition before it. He didn't identify.
It says I should not interfere.
Correct.
I think. Yeah.
Correct. He says you should not interfere in any circumstances. So my point is, if in 5 years we're still in this position and the JJC hasn't made a decision, you would still not have the power to interfere. And in my submission, that is so obviously wrong that the terms of this order would have meant that you had shut out the court from ever deciding that the stay could be lifted. It's simply, with respect, a very bad point and a very, very unmeritorious point, because what KPMG are asking you to accept is that these claims should sit in abeyance, both in the Dubai courts and here, indefinitely. There's been no reassurance given to you as to when the JJC will start deciding anything again. Of course, it's to KPMG's advantage if they can sit there indefinitely, but it's a deeply deeply unmeritorious position to say that you can't bury it. We also say that it's completely misconceived submission to say that there's been a compromise of the substance. And I just want to show you why, because one of the things the JJC would have decided if they'd proceeded to do so is whether or not there was a conflict at all. There has never been any concession that there is a conflict and therefore it has to be referred to the JJC. And that's very, very important, because once that's clear, it's clear that there's no compromise in the way that was suggested to you. So if we look, for example, at D6 342, page 342 of the bundle, these are my client's submissions to the JJC. And it's paragraph 2. It is evident that the conflict of jurisdiction application at hand is premature. The DIFC issued a ruling which it asserted its jurisdiction. By contrast, the Dubai court decided to stay the proceedings pending a decision by the Judicial Tribunal, did not decide on its jurisdiction. It follows that there is the contention there's a conflict is inaccurate because the Dubai court did not assert its jurisdiction over the claim. So it is perfectly possible for the JJC to decide that there is no conflict. It's never been conceded that all the JJC is deciding is which court this proceeds before. And so by agreeing that this would be determined by the JJC at a time when it was thought that would happen, certainly within a reasonable time, that is not making any substantive concession. And so it's simply wrong to say that there was a compromise of whether or not there was a conflict. That's never been the position, whether through that order or otherwise. The second point is obviously the point that you put to Mr. Montague-Smith. The order in terms says, it sets out that the court shall still have power to vary it in relation to implementation and timing. And that is true in relation to paragraph 1 as in relation to paragraph 2 and paragraph 3. It doesn't say that you ought to have power to do that in relation to certain paragraphs but not others. It's very, very clear that it's in relation to all of them. And indeed, it would be a very would have to be a very, very clear order that purported to shut out the court's ability to change what the parties had agreed and arguably wouldn't be enforceable in any event. But all that this order did was to agree that at that point in time, the JJC, because it was a thought and it must have been assumed by all that there would be a decision within a reasonable time, would decide the issue of whether there was a conflict or not. And that hasn't happened. And it can't be said that anyone entered into that expecting the JJC to do nothing for 18 months. Cannot be said that. Nobody in their right minds would enter into it. And the suggestion that you can't put that interpretation on the consent order because then we could apply the day after we signed it. Well, that's easily answered. If we applied the day after we signed it, the court would tell us to go away. We still have to persuade the court that there's a good reason to change and to lift the stay. And for obvious reasons, what's occurred here is absolutely extreme. No decisions at all, no indication of when anything will begin to operate. Secondly, on Mr. Montague-Smith's own analysis, the liberty to apply provision is part of the parties' agreement, which you must uphold and give effect to. But as I say, our primary argument is and remains that you have the power to do this. The parties can't, by agreement, shut out. KPMG have had the benefit of 18 months of nothing happening in relation to this claim. In relation to the Dubai court, again, in my submission, they can't use that to their advantage. They haven't applied back to the Dubai court to lift the stay. What KPMG would like to happen now is for nothing to happen in relation to either the claim and for the JJC to make no decision. For obvious reasons, they think that will be in their favour, but that's not something that the court should endorse. If I can then deal with conflict, because we don't see it as there being two conflicting lines of authority in the way suggested. Laxey, the court upheld your decision. Obviously, none of us know the facts, but they were very, very clear that despite certain things that had happened, that wasn't sufficient. And what the authorities say very, very clearly is you have to have both a positive and an unequivocal act in relation to jurisdiction. It's not sufficient to have one step on the way, as the respondents would put it. And
well, I tried to find the first instance decision in that case, which was under a different name. I think I was a bit naughty. I think I might have published it with naming the parties. And then when it got to the Court of Appeal, they anonymised it.
Okay.
But the material facts appear pretty clearly from the Court of Appeal, and that is there was in the Dubai and the onshore courts, there was an objection to jurisdiction, which the court never decided. They dismissed the claim on the merits, and because they dismissed the claim on the merits, they didn't have to decide the question of jurisdiction. So then the question was whether that was an exercise of jurisdiction which conflicted with the jurisdiction being exercised in the DIFC, and I said it wasn't. And the Court of Appeal upheld that decision. I think that's how it went.
Yes, but the point was in that decision, having a decision on the merits wasn't sufficient, because where you have an extant decision on jurisdiction, you have to have the court expressing a view on that, whether it's by way of a decision or you have to have some reasons for deciding that you did or didn't have jurisdiction.
Again, if the decision had gone the other way, if instead of the claim being dismissed, judgment had been entered in favour of the claimant, then I think I probably would have come to a very different view. And that's really the line where I think I differ a little from Sir Jeremy is that, as I think Mr. Montague-Smith puts it, I take a much more, if you like, fact-dependent approach, which is more dependent upon the particular facts and circumstances of the individual case, and that last year's is a good example. Because it's hard to see as a matter of principle why, and this is probably in favour of Sir Jeremy's lines, hard to see a matter of principle why the fact that the case was dismissed on the one hand as compared to being upheld on the other should make a difference as to whether there's a conflict. But it seemed to me that it did, for what it's worth. Whereas Sir Jeremy, I think, takes a much more, if you like, binary approach, where he says there has to be decision. And to be fair, in Lacan, the two options were left open. One was that there has to be a conflict of specific decisions on jurisdiction, or is it something less? So Jeremy's opted for the former. I think I haven't gone that far. But even when it's something less, every single authority says it has to be a positive act and it has to be unequivocal. Yes.
You have to have those two elements present. And in a sense, the fact that we are debating at length what something means or doesn't mean shows it's not unequivocal. And I'll come back to that. The second point is one needs to be a little bit careful about what's said in 5 holdings. And I completely accept that you say in terms it all depends on the facts. But on the facts of 5 holdings, the passage that Mr. Montague-Smith took you to was when you were discussing the fact that the parties had neither party objected to jurisdiction. So in a sense, the point you were making in that paragraph was, well, of course, there's not going to be any decision on jurisdiction because no one's objecting to it. So if you're looking for that, you'll look in vain. But here, I think there is a conflict. So again, you have to read that passage in the context of the facts, which was that because no one had raised jurisdiction, the court wasn't going to decide it. So it is important. And within that, the context of that, if we just look at it, it's page 790, you do use the word unequivocal yourself. So at the end of 51, you again, you caveat it because you say, at least in cases such as this, where both parties have submitted to the jurisdiction, if the other court is also unequivocally exercising jurisdiction by entering judgment, a conflict is clearly arisen. So you have used the word unequivocal yourself. Obviously, you then go on in 54 to say that it's very dependent on the facts. But you combine that with obviously Lacan, which repeatedly uses the word having a positive act. And I don't accept the construction of that judgment that Mr. Montague-Smith seeks to put on it. Lacan is clear in terms of saying in 35, page 770, all translations require a positive act on the court's part. And then at the end of 35, there must at least be an occasion for deciding to waive or not waive, as is clear from the other translations. And that's what we do not have in this case. In terms of the expert orders, again, I just remind you, from what you've said, and I know from the way you prepare these cases, it's incredibly thorough. But you're absolutely right when you reverted to the fact that the chronology here is important, and it's set out in detail in the evidence that we filed for this hearing. It's 249. And I'll take this relatively briefly because you can read it yourself, but you'll see at 14, at 248, first of all, April 2021, those hearings were adjourned to allow POAs to be put in place. But then actually on the 6th of May, it got referred before the POAs were put in place. So it wasn't that anyone was deciding deliberately not to appear. It was a problem procedurally. And then you will see then the POAs are put in place. 29th of June, AIML applied for the proceedings to be reopened, so as to allow them to challenge the jurisdiction. 30th of June, the hearing listed on the 18th of May took place, didn't consider the application to reopen, didn't issue a judgment on the merits, then appointed an expert to assess. And then on the 12th of July is when the jurisdictional challenge is put in. And then if we turn over the page 250, then we get 21, submit a request to determine the onshore, the jurisdictional challenge. And then this at 22, the Dubai court determined in 14th of July that the jurisdiction challenge would not be dealt with until the expert's report was submitted. So they've not rejected it. They've not said we are assuming jurisdiction because we've asked the expert to report. They've actually said we're not going to deal with this yet. It's still there. It's still to be determined. So you can't have a positive or unequivocal act when in fact what the court said is, yes, we know it's there, but we're going to deal with it later, which is in effect what's happened. Then when you come on to look at the stay, then again, you don't have anything that is positive and unequivocal in terms of what has happened with the stay. If we look at 327, we know at this point that the DIFC hasn't yet determined whether or not it has jurisdiction. So we know that they are, in fact, applying a pre-Lacan view. They're applying a different test. They are applying the test that once you have the mere existence of the two sets of proceedings, that's enough to lead to a stay being granted. And again, as Mr. Bajamal says, if they were deciding the jurisdictional objection, you would see some reasons, absolutely no reasons in there. And indeed, applying the test that we're applying in the DIFC, there wouldn't have been a conflict because the DIC wouldn't have ruled on their jurisdiction yet. So again, that would have been premature. So we can tell without having to go into the other points that Mr. Montague-Smith raises to say, well, you can't take a view of what the court is saying. We can see very clearly it can't be disputed because of the timing that they're not applying the same test as the Lacan test. And we can also see with this combined with Mr. Bajmal's evidence that the court had said that they were not going to decide the jurisdiction application yet. They don't within the context of this decision. And as he sets out, if they had, there would have to be some reasons, and we don't see any reasons. I'd ask you to disregard anything that's said about translation. Obviously, none of that's in evidence. It's impossible to deal with. It doesn't, in my submission, help in any event because it rather shows there's nothing unequivocal. But we don't know who was speaking to Mr. Montague-Smith during his submissions. But obviously, that's not a satisfactory way to deal with this. You have the very clear evidence that's been put in by Mr. Bajmal, who deals with these courts, saying that they haven't yet decided it. And that you can see that, secondly, from the face of these reasons itself and from the timing. The mere existence of these proceedings in both jurisdictions has led them to say, well, the JJC can decide it. Just one point, sorry, that I forgot on the deterrence point that was raised in terms of, well, you'd be deterring people from entering these. In my submission, that works much more strongly. You would, if this was found to be sufficient to mean that my clients cannot apply to the court for the stay to be lifted and the court can't exercise that, then that will be a massive deterrent to anyone agreeing anything sensible between solicitors in terms of what should happen. So again, I would ask you to reject that. On the face of this order, a sensible position was reached at that time. That's no longer sensible because no one has any idea if or indeed when the JJC will decide. And Mr. Montague-Smith says, well, no one's saying they won't decide. The position is completely unclear. No one knows. We could be here in another 18 months and nothing has happened. So there is no comfort that they will decide anything in the near future. It's simply unknown. We've waited 18 months before making this application. And in those circumstances, I would ask you to now lift that stay and to determine that these proceedings should proceed.
Well, thank you. I'm going to give my decision shortly, and I'll give reasons for that as well. That's going to take a little while. We've been going for 3 hours now, so I think it might be a good idea to take a short break before I do that. So can I suggest that we adjourn? Why don't we resume at 20 past the hour, if that'll give everybody a little break for comfort break, and just leave the lines open, turn cameras and microphones off, and we'll resume at 20 past the hour and I'll give my decision. That's convenient. Thank you. We'll adjourn until 20 past the hour. It's all up. If everybody's ready, we'll resume then. I'll give my decision now. This is an application to lift a stay that was made by consent of the parties in circumstances which I'll describe shortly. The procedural history of the proceedings in this court and in the onshore courts of Dubai are of some significance to the issues that have been resolved and so have to be resolved, and so I'll commence by referring briefly to that procedural history. The proceedings were commenced in this court on the 29th of March 2021 when 2 applicants issued a claim against 3 respondents alleging systemic failures in the audits by those respondents of the 2 applicant companies, suggesting that very substantial losses estimated at around $600 million were caused. There is a dispute between the parties as to whether the second respondent exists, and the first claimant has a claim against the first respondent, and the second claimant has a claim against the third respondent. The parties accept that the claim by the second claimant against the third respondent is clearly within the jurisdiction of this court, but there was an objection to the jurisdiction of this court to entertain the claim by the first claimant against the first respondent, and that objection to jurisdiction was eventually heard and determined by me in November 2021, when I ruled that the court did have jurisdiction. And in the course of that ruling, I expressed the view that it was desirable for that claim and for the claim by the second applicant against the third respondent to be heard together because of the interconnection between those claims. An application for permission to appeal was brought in respect of that decision, and that's still pending because of the stay to which I'll refer. In the meantime, and indeed a couple of weeks after proceedings were commenced in this court on the 18th of April in 2021, the first respondent, the first defendant, if you like, in these proceedings issued a claim against the first claimant in these proceedings in the onshore courts of Dubai, seeking declaration to the effect that the audits which had been conducted by the first defendant in these proceedings were carried out without any fault, and also claiming compensation against the first claimant in these proceedings for repetition of allegations made in the DIFC claim. And shortly after those proceedings were commenced, the first defendant in these proceedings, the claimant in the onshore proceedings, issued a petition to the JJC seeking an order that the Dubai court was the competent court to hear the dispute between first defendant in these proceedings and the first claimant, and also sought an interim stay of both the DIFC claim and the onshore claim pending the determination of the JJC petition. Now, in the meantime, the onshore proceedings went a little further in that hearings took place before the case management officer, and then there were issues with respect to the provision of notarised powers of attorney in relation to the representation of the first claimant in these proceedings and the first applicant in these proceedings. And then in May 2021, there was a hearing held at which the claimant in these proceedings wasn't represented because it didn't have notarised power of attorney. And at that hearing, the Dubai court declared a close of the proceedings. And then it was necessary for the claimant in these proceedings to apply for those proceedings to be reopened. But before that could happen, another hearing took place at which the onshore courts of Dubai didn't consider the application to reopen the onshore proceedings, but did instead appoint an expert to assess the underlying evidence and directed the expert to file a report. And that was on the 30th of June 2021. On the 12th of July 2021, after the case had been procedurally reopened, the first claimant in these proceedings lodged an objection to the jurisdiction of the Dubai courts. Then there were various requests made to the Dubai courts to consider the jurisdiction challenge, but in the result, the Dubai court determined that the jurisdiction challenge wouldn't be dealt with until the expert's report was submitted. The expert's report was submitted to the court on the 19th of September 2021, but then on the application of the first defendant in these proceedings, that is KPMG LG, the onshore court granted a stay of the onshore proceedings. And it's about that shortly thereafter, it was decided by me in this court that there was jurisdiction to entertain all the claims Then permission to appeal was brought, and then there were negotiations between the parties which led to a stay by consent. And I'll refer later to the evidence of those negotiations that resulted in the stay. Now, that stay was ordered on the 19th of January 2022. The terms of the stay are of some significance to the argument, so I'll just refer specifically to the terms of the order. There were 4 provisions to the order. The first is that until a final determination of the first defendant's application to the Joint Judicial Committee, Cassation number 8 of 2021, the first claimant's claim against the first defendant, including the first defendant's appeal of the jurisdiction judgment, is stayed. Second order is that the second claimant's claim against the third defendant is stayed until the stay under paragraph 1 hereof is lifted. Third order is that first claimant shall have 21 days from the stay under paragraph 1 hereof being lifted to submit respondent submissions pursuant to RDC 44.14. Fourth order is the party shall have liberty to apply as to the implementation and timing of the terms of this order. The application to the JJC, as I've said, was made on the 26th of April 2021. And despite requirement in the decree establishing the JJC, which requires applications to be determined within 30 days of the application being made, the application still hasn't been decided. And despite repeated inquiry, there's no indication as to when the application to the JJC might be decided. It is, in that context, an inauspicious fact that no rulings have been issued by the JJC since March of 2021. And so, if the JJC is still functioning, a matter which we simply don't know, it hasn't published a decision or hasn't made a decision which has been published for approximately 2.5 years. It's a fair inference which I draw from this undisputed fact that there is a backlog of applications to the JJC, of which this application is likely to be a part. Nevertheless, it remains the fact that all that can be said at this stage is that there has been very substantial delay in the decision in deciding this application, delay of more than 2 years since the application of the JJC was made. And we just don't know when that application will be determined by the JJC. The application to lift the stay, which was ordered by consent, relies upon 3 sources of power. The first is RDC 4.7, which provides that, and I quote, a power of the court under these rules to make an order includes a power to vary or revoke the order. The second source of power relied upon is the express reservation of liberty to apply in the 4th paragraph of the order which I read out. And the third source of power relied upon is the inherent jurisdiction of the court with respect to the regulation of its proceedings. I made observations with respect to the nature of an order for a stay in Credit Suisse AG against Emirates Hospitals Group 2021 CFI 060, and where I observed that an interim stay is of its nature temporary, and the power to lift a stay of that kind is not constrained by presumptions or onerous burdens and can be exercised in the interests of justice, including where appropriate in the interests of a proper case management and the service of the overriding objective established by the rules of the RDC. In particular, I established that there was no requirement for changed circumstances that conditioned the exercise of the power to review the question of whether a stay should continue. It's submitted that this case is distinguishable from the case in Credit Suisse because Order 1 of the order for a stay placed if you like, imposed the stay for a specific period, that is, until the decision of the JJC. I don't think that alters the character of a stay order, whether it is indefinite or whether it is for a particular period. I consider that the observations which I made in Credit Suisse apply to stays of all kinds, including for a fixed period or of an indefinite period. It is in the nature of a stay that it falls to be reviewed from time to time, depending upon the circumstances as they exist. And so I think there is that I don't think there is, in the nature of an order of a stay, there isn't a significant impediment that has to be overcome in order to cause the court to review it. I also accept that there is power, specifically in the fourth order of this stay, for the court to review the order from time on the application of a party. The fourth order, as I mentioned, is the parties shall have liberty to apply as to the implementation and timing of the terms of this order. Now, clearly, this current application is not concerned with the implementation of the order, but it is concerned with the timing of the terms of the order. The previous three orders in the order all have a temporal component. The first order is that until there is a final determination, is to operate until there's a final determination by the committee. The second order is to operate until the first paragraph operates, and the third order is to operate for a period of 21 days from the lifting of the stay. Clearly, in my view, the word timing in the fourth order, of the stay order, must relate to the times imposed by those three paragraphs. I can't see any reason to read down the word timing to not extend to the times imposed in those three paragraphs. So in my view, there is express reservation of liberty to apply in respect of the times for which the previous three orders operate. That, I think, goes a long way to blunting the principal argument that was advanced in opposition to the exercise of the power to lift the stay. And that argument is that if the court lifts the stay, it will in effect be assisting the first claimant to breach a contract which is embodied in the consent order. As I say, if one accepts, as I do, that the consent order contained within its own terms an opportunity for review of the order, it follows that any contract to make an order in those terms won't be breached by the exercise of the power that's contained within it. Now, it also, I think, needs to be observed that the order was made in a context in which the parties should be taken to have been aware of the provisions of RDC 4.7 and of the inherent power of a court to lift a stay in the interests of justice, to which I've referred. It's not suggested that there is any term of the contract which specifically prohibits or precludes a party from invoking the court's exercise of those powers. The only provision of the contract relied upon is the provision in Order 1 to the effect that the stay will remain in force until the determination of the JJC. But if the term of the stay is subject to either RDC 4.7 or the inherent power of the court to review the stay, or, as I've found, the express reservation of liberty to apply to review the terms of the stay, then it follows that the fact that there is a finite period expressed for the operation of the stay in Order 1 doesn't prevent those other powers being exercised. Because of that view of the nature of the contract, it's probably unnecessary to go into the very interesting argument that was presented to me by both counsel in relation to the principles governing the circumstances in which the court does or should exercise the power to vary what was an agreed position by the parties. It's not put by the first defendant that there is no power to vary a contract. Rather, it's put that the fact that there was an agreement between the parties is a very significant matter, which should induce the court to be slow to, as it were, alter an agreement solemnly reached by the parties. But the cases to which I was referred, and which I won't go to in detail, seem to establish that there is a distinction drawn between what is in effect a procedural accommodation between the parties on the one hand, and a real settlement or compromise of a disputed issue between the parties on the other. Because any contract that was entered into, in my view, accommodates the application which has now been made, it's unnecessary, as I say, to draw that distinction. But had it been necessary for me to identify, to classify this consent order, I would have clearly put it in the category of case in which there has simply been a procedural accommodation between the parties rather than a real settlement or compromise of a dispute. The first defendant has submitted that the agreement for the consent order compromised the issue of whether Decree 19, which created the JJC, mandated a stay in the circumstances of this case. I don't accept that submission. It doesn't appear to me to be supported by anything within the terms of the order or within the correspondence which preceded it. To the contrary, in that correspondence, the first claimant expressly asserted that a stay was not required because there was no conflict in the decisions of the two courts with respect to jurisdiction. The first claimant has never resiled from that position and indeed maintains that position in support of this application. So in those circumstances, it's not possible for me, I think, to conclude that there was any compromise of that issue merely by the issuing of a consent to a stay in the terms that were ordered. The claimant's application is brought on the basis that the interests of justice require the lifting of the stay, given the unconscionable delay which the stay has occasioned since it was granted in January of 2022. That application is bolstered by the prejudice which the claimants say they will suffer by being kept out of their claim, which carries with it a risk of assets being dissipated or appropriated by other creditors the longer it takes for their claim to be resolved, and the risk of jeopardy to the trial process through the degradation of evidence over time through the loss of documents or access to witnesses or the lapse of memory. Those assertions are plausible and are supported by evidence. It's well established in other contexts, for example, in context of cases relating to striking out claims for want of prosecution, that there is a presumption that significant delay impedes and diminishes judicial processes, and that presumption applies without the need for evidence. And it's clear that prejudice in being kept out of a very substantial claim of more than $600 million for a lengthy period is prejudice in itself. It's said, rightly, that these proceedings have a long way to go, and so it's said that some more delay in that context is not inordinate. With respect to that submission, I don't agree with that. The delay which has already been occasioned by reason of this stay has been the source of prejudice. That prejudice will be exacerbated the longer that delay goes on. And so in my view, the sooner these proceedings are put back on the rails, the better, provided, of course, there is no impediment to that course by reason of the existence of a conflict of jurisdiction. But it seems to me that the inordinate delay which has been experienced to date, the prospect of further indefinite delay for an unpredictable period, creates a powerful argument that the interests of justice require this Gordian knot to be severed. And so even if I had come to a contrary view to the effect that this was one of those cases in which the parties had compromised their dispute by the making of a consent order, I would nevertheless have considered that this is one of those possibly rare cases in which the court would be justified in nevertheless varying the agreement between the parties, because the injustice that has been occasioned by the delay to date and that would be occasioned if this delay were allowed to continue is profound and would justify the course of interfering with the parties' bargain. I think, let me just check my notes. The other point I'd make in this context in relation to the hardship is the defendant's submission that the evidence fails to establish that the claimants expected a prompt decision from the JJC. I don't accept that submission, which it seems to me is contrary to the evidence. The evidence of Ms. Kitt, a partner in the law firm representing the claimants, paragraphs 29 and 30, is to the effect that the claimants believed that there would be a decision from the JJC within a reasonable period. That belief was sustained by inquiries which had been made by their legal representative, Mr. Bajamal, who deposes in his, or states in his witness statement, that in the period of weeks prior to the consent order being agreed to, he attended upon the registrar of the JJC, was advised by the registrar that the application had been considered but not determined, and that the registrar expected that the application would be determined at the next meeting of the JJC, although it wasn't clear when that meeting would be held. That, I think, provides a sound evidentiary basis for a belief that there would not be protracted and inordinate delay. The counsel for the first defendant, senior counsel for the first defendant, makes the point that there had already been delay by the time the consent order was made, but that, I think, is a fact that counts both ways. The fact that there had already been substantial delay might have occasioned a belief, or perhaps reinforced the evidence of Mr. Bajamal to the effect that the delay had induced a belief that the application might have reached the point where it was approaching determination. And so I don't accept that the first claimant was not entitled to believe that the application to the JJC would be determined in a timely way. That, I think, leaves for substantive determination the question of whether I can lift the stay, given that for all the reasons I've enunciated, it seems to me to be very much in the interests of justice to do so if there is no impediment to that course. And that question turns upon whether there is a conflict of jurisdiction within the terms of Decree 19 creating the JJC. In that context, the defendants submit that the Dubai Court assumes jurisdiction when it takes any positive step towards determining the merits of the case, even if there is an undetermined objection to jurisdiction. The defendants further contend that because it was held in Lacan that something less than final judgment on the merits will suffice to give rise to a conflict, and it is the invariable practice, it said, of the Dubai Court to not rule on jurisdiction until its final determination on the merits. There must be some point at which a conflict can arise prior to the determination of the objection as to jurisdiction. The latter submission, I think, rather overstates the evidence with respect to the practices of the Dubai Court. I don't think the evidence sustains the conclusion that it is the invariable practice of the Dubai Courts to never determine jurisdiction prior to final judgment. Counsel for the claimants has pointed to a case where such a determination was made in the course of running the case, and I've myself come across cases in which that has occurred. The true position seems to be the practice of the Dubai Courts vary. Sometimes the objection to jurisdiction will be reserved to determination at the same time as determination on the merits. Other times, the objection to jurisdiction will be determined in the course of running the case. It's further submitted that the Dubai Court's stay presumes that it has determined that it is exercising jurisdiction. That submission, I don't think, is supported by the evidence, and in particular, the evidence of the terms of the court's decision, admitting that we rely upon an interpretation of what was decided. But the interpretation that we have in evidence is to the effect that the stay of the Dubai Courts was based upon its conclusion that neither that court nor this court had renounced jurisdiction. That, I think, is quite a different thing to a determination that the court had determined to exercise jurisdiction in a context in which the Dubai Court has not specifically refrained from determining the question of the objection to jurisdiction. It is, I think, a fair inference that the court that determined that application took a different view to the construction of the decree, which has been taken in this court since the decision in Lacan and Lamia, in which this court has made it clear that there must be positive decisions, or at least a positive exercise of jurisdiction, before there can be a conflict of the kind that requires a stay under the terms of the decree. So the question then is, in the particular circumstances of this case, is there a conflict of jurisdiction? And I was taken through the authorities very helpfully by counsel for both parties in that regard. The decision, of course, that changed practice in this area is the decision of the court in Lacan and Lemire, which expressly left open the question of just what was required to give rise to a conflict of jurisdiction, and in particular, whether each court had to specifically make an express ruling as to its jurisdiction in order to give rise to a conflict, or whether something less, such as the exercise of jurisdiction in a position of conflict, could create a conflict. Since that decision, there hasn't been any authoritative decision of the Court of Appeal resolving that issue, although there is one decision of the Court of Appeal on an application for permission to appeal, to which I'll refer. But there do seem to be different views taken by different judges at first instance on that issue. In two decisions of Sir Jeremy Cook, he has taken, I think quite clearly, the view that an express decision on jurisdiction of each court is required before there can be a conflict. Those two decisions are the decisions in DIFC Investments against Dubai Islamic Bank, which is at 2022 DIFC CFI 024, and Mushrek Bank PLC against Infinite Partners Investments LLC, which is 2020 CFI 063 at paragraphs 16 and 17. I have not myself adopted that particular view. I've taken a rather more fact-specific or fact-dependent approach to the issue, in which I've taken the approach that one must look at the individual facts and circumstances of the case and then ascertain whether the mischief which the decree can be seen to have tried to avoid in terms of either inconsistent judgments or wasted cost and expense by the same issue being tried in both courts at the same time would be advanced if there was a stay. And that's the view I expressed in 5 Holding Limited and also in another case as well. And the approach which I take much depends upon the individual facts and circumstances, and there are no, on that basis, there are no, if you like, bright lines that indicate which side of the line the case will fall on. Perhaps that proposition is best illustrated by the decision reported in the Court of Appeal as Lazia, which is Lasya v. Labuki, which is Labuki 2022 DIFC CFI 083. In that case, there's no doubt that this court was exercising jurisdiction, but the question that determined whether there was a conflict was whether the onshore courts of Dubai were exercising jurisdiction. What had happened in those courts was the proceedings had been commenced, an objection to jurisdiction had been made, but then without determining the objection to jurisdiction, the court dismissed the claim on the merits. I took the view that because there'd been no occasion for that court to determine whether or not to exercise jurisdiction, because it had decided that even if it had jurisdiction, it wouldn't exercise it because the claim would be dismissed, there wasn't a conflict of a kind that enlivened the mischief to which the decree was directed, because to all intents and purposes, the proceedings in the onshore courts of Dubai were concluded. Application was made for permission to appeal from that decision to the Court of Appeal, and that application was dismissed, where the Court of Appeal basically expressed the view that my reasoning was appropriate and there hadn't been any conflict because there hadn't been an occasion. In the circumstances of this case, the observation made by the Court of Appeal in paragraph 5 in Lacan seems to me to be particularly pertinent, and that was to the effect that before a conflict can arise, there must be an occasion. This was the observation was made in a particular portion where an attempt was being made to construe different interpretations of the decree. The observation was to the effect that before there can be a conflict, there must be an occasion for the court to decide whether to waive or not to waive jurisdiction. And that's why I think the particular circumstances of this case are significant. There's no doubt at all that this court has decided to exercise jurisdiction, subject, of course, to the application for permission to appeal. So that circumstance may change, but as things stand at the moment, this court is proceeding to exercise jurisdiction. The question, therefore, is whether there has been there have been action on the part of the onshore courts of Dubai which gives rise to a conflict in jurisdiction. The timeline that I set out earlier is, I think, of particular significance in that regard, because the step upon which great reliance is placed by the defendant is the step to appoint an expert to produce a report to the court. That step was taken before the case had been reopened, therefore before the claimant in these proceedings had been given an opportunity to lodge the notice of objection. After the notice of objection to jurisdiction was lodged, the court took no further step other than to grant the stay. Now, it seems to me that in those circumstances, there simply hasn't been an occasion to either waive or accept jurisdiction after the objection to jurisdiction was lodged with the Dubai court. For that reason, it seems to me that this is not one of those cases in which there is a conflict in the jurisdiction between the two courts. It's said also that I should take care in not, as it were, interfering with the decision of the Dubai court to the effect that it had itself exercised jurisdiction. If that were how I construed the decision of the Dubai court, I would be very cautious. That's not how I construe the decision of the Dubai court. The reason I've given earlier, it seems to me that the Dubai court has not decided whether or not it will exercise jurisdiction. It has simply granted a stay of the proceedings, apparently taking a different view of the operation of the decree to that taken by this court. That, of course, is not to say that this court is correct in its view of the decree, but it is, rightly or wrongly, it is the view which this court has taken, which is established by the decision of the Court of Appeal. It's said that if I were to lift the stay, that would cause great prejudice to the defendant because it has obtained a stay in the onshore courts and these proceedings would continue, whereas the proceedings in the onshore courts would be stayed. There are two answers, I think, to that submission. The first is that, of course, it would be open to the defendant to apply to lift the stay granted by the onshore courts based on the decision that's been taken by this court. It's said that an application of that kind would have little prospect of success. I'm not sure about that. One never knows until these applications are made. The more important point, I think, is that the position taken in the onshore courts can't, I think, affect this court's decision as to whether or not it has jurisdiction. This court has determined, subject to any appeal, that it has jurisdiction. In my view, there is no conflict in jurisdiction preventing this court from exercising its jurisdiction. And the fact that a different view of the decree may have been taken in the onshore courts of Dubai is not, in my view, sufficient reason for this court to fail to exercise the jurisdiction which it has found it has. That failure, in my view, would be the source of very considerable prejudice to the claimants who wish to pursue their claims in this court. And so I just check my notes and see that I've covered all the points that I think I need to raise. Yes, so for those reasons, I don't think there is any conflict of jurisdiction within the meaning of the decree, therefore open for this court to continue to exercise its jurisdiction. In all the circumstances of this case, given the inordinate delay that has occurred to date, I don't think there is any impediment to this court exercising the power to lift the stay, and indeed, to the contrary, I think it is very much and very strongly in the interests of justice for this court to do so. So the orders that I propose to make are that the stay will be lifted. It follows that consistently with the terms of the stay, the first claimant has 21 days from today within which to file its submissions in response to the application for permission to appeal. In relation to costs, I'll hear counsel, of course, but my suggestion would be either that costs be in the cause of the proceedings or that they be reserved. The reason for that view is that this application has come about through no fault of either party. It's come about because of the position adopted by the JJC, and it seems to me in those circumstances the fair result is that the loss should fall to whoever loses the litigation, and therefore the costs might be in the cause. But I'm open to persuasion otherwise.
My learned friend's probably got some suggestions, but I think firstly, I don't know whether she maintains it, but she was seeking a variation of that 21-day time limit.
Is that right?
To 28
Yes.
days.
Yeah, would
that right,
you
Liz
ask
Day?
for 28 days? Yes, it's in the draft order,
Yeah.
which is at
Oh,
page
sorry,
166. So
Is there any
it's
objection
just
to that, Mr.
that it,
Well, if Mr. Montague Smith doesn't object, that'll be the order then. You'll have 28 days.
I'm grateful.
Thank you.
There was one or two other bits and pieces that my learned friend was looking for in the draft order in relation to timing of the defence and various other things, and reply, for example. It seems to us that those things can wait because everything's going to have to wait anyway, unless my learned friend wants to press that. I'm also slightly conscious of the time. But in relation to costs, it seems to us that the best approach would be to reserve the costs, because ultimately we do think that the JJC will come up with a decision, and if you make it costs in the cause, then maybe there is no cause ultimately in this call. But so that would be our preferred outcome.
Yes. Ms. Day, what do you say about costs?
well, Your Honour, both sides ended up serving statements of costs, and I've no doubt that if this application had gone the other way, Mr. Montague Smith was going to apply for those costs. I do say that since we issued this application, originally we did say costs of the application are reserved, but we do have concerns about the response to this application has been to take every conceivable point. It has been costly to deal with it in a way that in my submission was unnecessary. Now, whether that's reflected in the order that's made, but it would be unsatisfactory that they're left for someone else to look at when you yourself obviously have knowledge of how this hearing's been conducted. And as I say, every single conceivable point has been made. It's not as if the respondent said, well, it's a tricky situation, it's up to you. They have taken every single point. It has cost a lot of money, as you've probably seen from the cost schedules. So we would be keen to ask for an order in relation to that, alternatively cost reserved.
Well, I don't need to hear from you, Mr. Montague Smith. I don't think the quantum of the costs can alter the question of principle. I think the question of principle is that we really need to see, essentially for the reasons I expressed earlier, Ms. Day, I think we need the proper exercise of the discretion to costs needs all the relevant facts and circumstances, and I think it's best to reserve so that all those facts and circumstances, that's not to say you won't get your costs eventually and you may get them all, but I think it is best to reserve the costs in these circumstances. Now, just looking now, and I should have looked at this earlier, for which I apologise, looking at your draft order, just in relation to you don't propose that there be any pleading until the permission to appeal application is resolved, do you? Ms. Day, that's I think in your draft.
Yeah,
well,
I don't. That's in the draft. Then that was where we'd got to. Obviously, we hope there'll be reflection on what's occurred, and some sense of trying to deal with this as cost effectively as possible. But yes, we have set that out.
In case it's helpful, Your Honour, sorry. So there is already an order which has been made to the effect that the time for the acknowledgement of service is deferred until 14 days after the outcome of the appeal. So we already have that timeline. So it's just in case that assists. I think that the proposal is to sort of then build on from there a timetable. But it seems to me we can revisit that in due course if we need extra time.
Well, is there any advantage in trying to put a timetable in now? Because the next step will be the application for permission to appeal, which will presumably come to me. And then I'll have to resolve that. And if I grant permission, then it'll go off to the Court of Appeal, and months will pass. If I don't grant that, then it'll probably go off to the Court of Appeal anyway. So on a review of the refusal of leave. So I just wonder if there's any point now putting a timetable in, Ms. Day.
We're in your hands in that regard.
I think it's all just a bit too imponderable. If and when the appeal process comes to an end, you can ask whoever has brought it to an end to make those orders, depending on the time of year and so forth. And it could be influenced by things like holidays and things of that sort. One never knows. Although I would say, Mr. Montague-Smith, for the benefit of those who instruct you, I don't think it would be when the time comes for specifying times for a defence, if this court does end up exercising jurisdiction, I don't think your clients would be entitled to say they've been sitting on their hands during all this while all this time is passing. I know there is a risk of costs being thrown away, but I still think in the nature of this case, they should be taking steps to prepare for the defence.
I've heard that indication. I will obviously those instructing me have heard it as well. All I'd say is that up until just now, there's been a stay in place. So if we had spent money, then it wouldn't even be recoverable. So but I understand going forward the position is different.
Yes. All right. Thank you. Oh, well, is there anything else then? All right.
No,
well,
I don't think so. Safe to say thank you for sitting so late. We're both very conscious how late it must be for you.
I'm sorry I've kept you into the early evening, but it's fine for me. So thank you, and thank you both for your assistance. I found the arguments very interesting and very helpful too, as always. So
thank you.
So thank you, Counsel. Thank you.